Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please.
Good morning.
Case number 21-7021, National Railroad Passenger Corporation doing business as Amtrak versus Southeastern Pennsylvania Transportation Authority appellant. Mr. Pills for the appellant, Mr. Marotta for the appellant.
Good morning. Counsel for?
Eric Pills, Your Honor, counsel for Southeastern Pennsylvania Transportation Authority.
Yes, thank you. Please proceed.
Thank you, Your Honor. May it please the court. In 1982, SEPTA and Conrail did everything required by the Northeast Act to convey the commuter easement to SEPTA so SEPTA could assume Conrail's commuter operations in Philadelphia. SEPTA recorded the commuter easement in 1983 and has used it ever since for its operations. After more than 35 years without challenge, Amtrak filed this suit claiming that it owns the commuter easement and that its rejected offer of a tender of a contract option in 1982 prevented Conrail and SEPTA from completing the Northeast Act transaction. The district court agreed. The district court erred because granting Amtrak's claim is contrary to the Northeast Act, is contrary to the terms of the option itself, is contrary to real estate law, and is barred by the statute of limitations.
Well, let me ask you just a question to help clarify my thinking. The option that Amtrak is referring to, as I understand it, is the option that was created in 1976. That was part of it's called Exhibit A, Computer Passenger Service Agreement. And that was part of the Northeast Corridor Computer Operating Agreement of 1976. Is that correct?
Almost, Your Honor. It was created as part of the commuter easement in 1976. It was actually originally attached to the deeds that conveyed the Northeast Corridor from Conrail to Amtrak as a reserved right on behalf of Conrail. The document you're referring to, which we have included in the joint appendix, is a reproduction of that.
So is your answer yes or no?
My answer is that is the commuter easement. That's a reproduction of the commuter easement.
The answer is yes, that the option Amtrak is invoking is the language that appears in the 1976 agreement. Is that correct?
Yes.
All right. So then, as I understand the chronology here, is a number of things happen, but the salient thing, and this is where I'm questioning you, is that as time passed, Conrail did not work out as Congress had contemplated it would. And so Congress took further action, namely in the 1981 Act, where it created another scheme, and specifically your client is invoking Section 506B of the 1981 Act, which appears at, let's see, your addendum to the opening brief at page 76. Is that correct?
Yes, Your Honor.
So why, given that Congress changed the scheme once Conrail failed, why is the 1976 option relevant now?
It's
relevant after the 1981 Act.
Our position is that it isn't relevant, that the effect of the 1981 statute was to make the option ineffective, at least certainly at that time, and could not be used to prevent Conrail from conveying the commuter easement to Amtrak.
That's your biggest argument in this case is Section 506, isn't it?
Yes, Your Honor.
Well, the thing that, we're all textualists now, and that language says a commuter authority may initiate negotiations. Now, why do you take that to be an overriding of everything that came before and granting a right to SEPTA? I don't get it.
Because
May initiate negotiations. That you want that commuter easement free, but why? I don't understand. It may initiate negotiations. Sounds like you can initiate negotiations, but if there's no if there's disagreement, of course, there's a procedure whereby the government agency decides. But where does it say you get it free?
Well, there was a transfer agreement that included consideration, and the bigger context here, which is
Wait a minute. Which transfer agreement?
there was a September 1, 1982 transfer agreement between Conrail and SEPTA that specified all of the properties and rights that were being transferred and conveyed from Conrail to SEPTA to enable SEPTA to take over
But
the.
this deals with the question of Amtrak's rights, right? Why do you take the position that may initiate negotiations gives you a right against Amtrak that eliminates the option?
Because once negotiations were initiated, the Act then specifies that the parties shall specify the rail properties to convey and
Wait a minute. Where's the shall? I do see the word shall in other parts of Section 506, but I don't see it in B1. I see it in C, I see it in E, but I don't see the word shall.
in B2, 1, in B2, any transfer agreement between such commuter authority and Conrail, and I'm looking at page 76.
Any agreement shall specify,
Right.
but it doesn't say that there has to, that just says you may initiate negotiations. That's words that doesn't sound like you have a legal right. Why do you have to negotiate if you have a legal right?
The scheme that Congress put in place here is that the parties would negotiate and reach an agreement on what was to be transferred, which rail properties were to be transferred. And once that agreement was reached, that transaction had to close by the end of that year, December 31, 1982.
When the agreement was reached, if it was reached.
Correct.
And so that doesn't, I don't understand why that gives you a legal right to get it free.
Well, it isn't a question of free because there was a transfer agreement that included consideration and it was part of the overall transfer of Conrail's authority to SEPTA as provided in the Northeast Act. And the point here, I think, is that Congress said, here's the process for figuring out how to transfer the assets from Conrail to the commuter authorities. Negotiate, reach an agreement if you can. If not, there's a series of mandatory steps. Once that process was initiated by SEPTA, the rest of the process was required by statute, and whatever was specified in the transfer agreement was required to be closed by the end of the year and conveyed to SEPTA so that SEPTA could continue the operations that Conrail had been performing.
Where do you see that?
Doesn't Section 506, which is entitled Property Transfer, subsection A, gives the choice to each commuter authority to notify Amtrak commuter and Conrail whether it intends to operate. And so then B1 is a commuter authority may initiate negotiations with Conrail for the transfer. And then it goes on later in 506 to say, well, if no one comes forward, then Amtrak commuter is to run this. There's no an Amtrak commuter is an entity created in the 1981 Act and is separate and apart from Amtrak.
That's correct, Your Honor. And again,
So
and that is,
why doesn't that, what I'm trying to have you focus, and I don't know whether Judge Silberman will agree, but the point is that whole section in the 1981 Act is, here's how the property is going to be transferred. And Conrail has failed. So now what do we do? And Congress, this is Congress's answer. So the choice was up to these local commuter, or what Congress calls each commuter authority.
that's right, Your Honor. That is how we read the statute. And because this is Congress's scheme for transferring the assets of Conrail to the appropriate commuter authority, that overrides any statute, any private contract
But
obligation.
your key language is may initiate negotiations, right?
Yes. But it's,
Well, I don't understand why may initiate negotiations gives you a legal right to get it at your pleasure.
it's a statutory option that once exercised, then the negotiations start, the parties reach an agreement, and then the property is to be conveyed. That was the process that Congress.
But where's the agreement?
There was an agreement. I don't have the record cite, Your Honor, but there was a transfer agreement that was executed by SEPTA and Conrail on September 1, 1982, as provided by the Act, that specified, among other properties, the transfer of the commuter easement. We fully complied, and then on December 31, 1982, SEPTA and Conrail closed on that transaction, and the commuter easement was conveyed to SEPTA. We completely complied with the Act and followed the process that Congress laid out for effecting the transfer of Conrail's
I
assets.
see. One more point. Your point is Amtrak's option was eliminated by virtue of this statute.
Yes, sir. Yes, sir.
That's your basic theory of the case.
Yes, that's correct, Your Honor.
Mr. Fusk, I thought you were also relying on the final plan under the 1975 Act as well.
We are.
As creating a right in SEPTA and then also an option to acquire or to lease these properties. I mean, did NERSA override the final plan or supersede the final plan in some way?
No, it's in that instance, it supplemented it. It did not take away the right. And in the supplemental joint appendix, I don't have the page cite off the top of my head. There's a letter after the Northeast Act from the U.S. Railway Association reaffirming that the Section D rights did not go away. And further, I would point out that, as I think Judge Rogers pointed out, when you go through the Northeast Act scheme, at the end of the day, even if Amtrak commuter had received Conrail's assets, the commuter authority could still at that point have required the transfer of those assets to the commuter authority if it then chose to operate its own service, which mimics the Section D right. So it provides a second independent avenue.
Right, because I admit I'm somewhat skeptical that NERSA itself gives you this right, because it talks about initiating negotiations, which doesn't seem like as firm of a right as from the 1975 Act and Section D of the plan. So I'm wondering which of these are you relying on? Both?
We are relying on both, and we, as I said, I believe first that the Northeast Act itself, by setting in place a process that is initiated by the commuter authority, by SEPTA, for the parties to work out how they're going to do the transfer, but the transfer itself is required. That is sufficient under Connolly and the other cases to prevent Amtrak from exercising its option.
What is your textual reliance language in the final system plan? And what is the specific language on which you rely?
It is, apologize, Your Honor. Section D, and this is at, I apologize, I don't have the.
Section D says the following rail properties of the below named railroads. Is that the one?
Yes.
Well, what's the key language? It says may be purchased or leased. May be purchased or leased. Now, why the devil does that give you a legal right?
Because we exercised the right to purchase it.
Well, at what price?
I don't know that there was a specific price for the
Well,
easement.
then why do you have a claim that it's free?
Because the entire Northeast corridor, including the commuter easement, was divided up by Congress through the final system plan among the various rail modes, freight, intercity, and commuter rail. And no one was paying anything for any of this.
Well, wait a minute, may be purchased or leased. That implies a negotiation and an arrival at a figure. That doesn't give you a legal right to get it free.
But we did negotiate in the transfer agreement for the transfer of that asset among the other assets, and that was satisfactory to Conrail. I think that's more than sufficient.
Well, you know what's a little puzzling about that? When did Conrail give the option to Amtrak?
In 1976.
When exactly?
The easement was dated April, I forget the date, I want to say 3rd, 1976.
And you know what? That's after the system plan is published. So obviously Conrail was not under the impression then that it was obliged to give this property to a commuter company like SEPTA. It was thinking that it gave Amtrak the option.
Well,
Actually, when you go back to the 1976 statement, it's talking about when, let's see, how does it say it? It says, it's talking about the grantee and grantor, and Conrail is the grantor, the grantee is Amtrak. And it says, blah, 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 and I'm at JA 238 to 239. It says, the grantor shall elect to abandon or assign commuter passenger service easement in whole or part to affiliate, blah, blah, blah. The grantee, Amtrak, shall have first option. Well, all of that notion about Conrail being in charge and electing what the 1981 plan indicates, not the plan, but the act, is that by 1981, Congress had determined that Conrail was a failure in the sense it wasn't carrying out what Congress had intended it would do. And so Congress changed the system. So this whole notion that Conrail had any election disappeared. Now in the 81 Act, Congress says, here's how we're going to do it. Section 506. And it says either one of these local groups is going to say, we want to do this commuter passenger service, and enters negotiations about it. And if they can't agree or whatever, then all of this is going to go to a new entity created by the 1981 Act, namely Amtrak Commuter, which is distinct from the Amtrak before us in this case. Isn't that correct?
Yes, Your Honor.
So when the district court focused on the language that Judge Silberman's first question made, talking about, well, all the 81 Act says is may negotiate, may enter into negotiations. Was this argument that I've been asking you about presented to the district court?
Yes, it was definitely presented, Your Honor. We relied heavily on the same line of argument that the Northeast Act effectively made unenforceable Amtrak's option precisely because the effect of the Northeast Act was to change the scheme and to shift the operations from Conrail to the commuter authorities or Amtrak commuter at the commuter authorities option.
Let me just say, because the chronology is so critical here, I found it very confusing to name these statutes anything other than the Act of 1976, the Act of 1981, whatever it was. so that we're clear. So when you're speaking of the Northeast Act, what are you referring to?
The 1981 Act.
Precisely. All right. So that's the new scheme Congress has come up with. And either one of these local groups is going to come forward and negotiate and they'll have an agreement, or it won't. And so Congress says if it doesn't, then all this property that we haven't otherwise reserved to either contract to Conrail or Amtrak goes to this new entity, Amtrak Commuter, sorry. And I didn't understand why the district court didn't pick that up. I mean, the district court is as bright as anybody. And so I thought, well, maybe this wasn't argued to him.
It was argued, and that's why it's an assignment of error on our part. We believe he simply missed that. And as we said in our brief, he gave very short discussion of Connolly and that line of cases and really did not give full effect, we believe, to what the 1981 Act required and provided.
Counsel, will you do me a favor? I couldn't hear exactly my colleague's question. Would you specify what you're talking about?
She was asking whether we had, SEPTA had presented this argument.
Which argument?
The statutory argument that the 1981 Act prevented Amtrak from exercising its option, whether we made that argument below.
Oh, that's the core of your case.
Yes, sir. And we did.
That the 506 overrode the option.
Yes, Your Honor.
Dissipated it, zipped it out of the world.
Yes, Your Honor. That is the argument, and we did make it below.
Yes, and I have difficulty seeing the language giving you that.
And all I'll say, Your Honor, is that the 1981 Act gave the option to SEPTA to initiate a process pursuant to which the assets of Conrail would be transferred to SEPTA so that SEPTA could continue the operations of Conrail that Congress was terminating. That process itself...
There's no question, you're right, that Congress gave Conrail the right to initiate agreements.
No, the statutory language is that, with all due respect, of 506 is that the initiative is placed in these local authorities, not in Conrail.
No question that I agree.
All right.
That, wait a minute, let's see if I've got the right language in front of me.
And then our point, Your Honor.
Just to say, 506, yes. May initiate negotiations.
It's the computer authority.
And once those negotiations are initiated, then that is the process by which Congress designated to effect the transfer of assets from Conrail to SEPTA. And our point is that is the process that Congress put in place. A private contract option can't prevent it from being carried out.
And that's clear from subsection A, that each commuter authority shall notify Amtrak commuter and Conrail whether it intends to operate. So the initiative lies with the commuter authorities, and Congress contemplated, well, if none of them came forward, or they couldn't reach agreement, then this property was going to go to Amtrak commuter. I want to be clear, what was your response to Judge Rao's question about the final system plan? I wasn't clear about your response.
We are relying on both the statutory argument under the 1981 Act and the rights conferred in Section D of the final system plan. They're independent and complementary because the 1981 Act effectively reproduces that right, because at the end of the day, even if everything had gone, all the assets had gone to Amtrak commuter, SEPTA could still have requested or required those assets to be transferred back to SEPTA or over to SEPTA. So the
implications, if I understand you correctly, of the final systems plan is that the subsequent action on the part of Conrail, giving an option to Amtrak, was illegal.
I don't believe it was illegal at the time. We certainly don't take.
Well, no, you say it's inconsistent with the final system plan, and it came after the final system plan by some months.
No, Your Honor. What I meant to say was that Section D of the final system plan gave SEPTA an independent right to get rail assets, including the commuter easement and rights in the stations. And so that.
Then how do you explain Conrail's subsequent giving an option to Amtrak in the face after and implementing the final system plan?
Well, my point is that they could give the option, but that option can't be applied in a way that would deprive SEPTA of its rights under either the final system plan or the 1981 Act.
Well, an option, if an option that isn't effective, is not an option at all.
Well, not with respect, not when Congress, through the final system plan and through the 1981 Act, has said that these assets need to go to SEPTA. Now, there may have been other transactions.
Now, how can you explain what Conrail does then? Conrail, way after the final system plan, gives an option to Amtrak. If you're right, they're acting illegally because under your theory of the Section D, that they were required to give this to SEPTA.
Only if SEPTA asked for it, and the option itself could have been applied. There could have been circumstances when another entity could have tried to acquire the asset.
That's not the way the option is phrased.
Well, the option is back in 1976. The plan comes along in 1975. And in Section D, which is at JA 194, it talks about the following rail properties, blah, 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 designated to be transferred to Conrail in Section A of this appendix may be purchased or leased from Conrail by a state or local. Well, that whole system is out of the window, as it were, given that Congress comes along in 81 and says, we have to make changes in light of what's happened to Conrail. It's not working as we intended. So here's what we want to do. And that's Section 506. So unless this plan is somehow embodied in the 1981 Act, which I don't see it in either Section 506A or B, I'm not clear why SEPTA is relying on it at this point, or why it has any legal effect at this point after Congress has said in the 81 Act, it's the choice of the local authority. If they come forward and initiate negotiations with Conrail and they can reach agreement, fine. If they can't or none comes forward, then this property on the local commuters goes to this new entity that we have created, Amtrak Commuter. So I'm done. I understand your argument, Counsel for SEPTA, when you say this Section D of this 1975 plan, which was developed under a different statutory scheme, has resonance after the 1981 Act. It may, but I need it explained to me.
Well, I think our position is simply that under either Section D or the 1981 Act, there is a mechanism for SEPTA to obtain the commuter easement. And there's nothing inconsistent about the two. It's a question of which set of rights are we using.
What Judge Silberman's questions are getting to, as I understand them in part, is that if there was this 75 agreement, or no, what is it? Not 75. Yes,
76.
July 26, 1975, final system plan. Then until the 1981 Act is passed, Amtrak has both Conrail and Amtrak have some rights that were developed under a different statutory scheme. And that's what I'm not clear when you say they're complementary.
Well, even under the 1981 Act, under 506 subsection E, even if everything had gone to Amtrak commuter, SEPTA still had a right to obtain, or could still have the ability to obtain those assets from Amtrak commuter for itself. And
Right, but we're not there. That's down the road. The first step is in A, that each commuter authority shall notify Amtrak commuter and Conrail whether it intends to operate. Then that commuter authority may initiate negotiations with Conrail for the transfer, and any agreement that they reach has to include the service responsibilities, the rail property, and a transfer date that's not later than January 1, 1983. I mean, what went on before under a different statutory scheme, it seems to me, unless Congress somehow indicated all this remained relevant, but it didn't because the factual circumstances had changed. Congress originally thought Conrail was going to be the solution, and it proved not to be, according to Congress.
And our argument is simply that everything you've said I agree with about the 1981 Act. The Section D, however, is not in any way inconsistent with that because it gives SEPTA the right to obtain the same assets from Conrail.
No, but then it seems to me Judge Silberman's questions, well, I don't know what the word is, have more resonance because you're dealing under a previous statutory scheme. And so Amtrak's rights under that system agreement may have been different than they were after Congress passes the 1981 Act. And I thought that was the point that you were trying to make in the district court.
And the point that we're making with respect to Section D is that the things that were changed in the 1981 Act, the thing that it changed about the final system plan had to do with Conrail and its operating authority and its property rights by requiring them to be transferred to entities like SEPTA. And that's exactly what Section D already provided. So that wasn't, we don't believe that was affected by the 19...
Exactly, that's my point, counsel. That was talking about an election that Conrail makes, et cetera. And that's all out of the window now. It's not Conrail's election to make. Congress says it's these local authorities to make because we've decided that's the way it should go. And if that doesn't work out, then we've created this new entity called Amtrak Commuter, and they're going to handle these properties.
Oh, they're going to handle them less.
Understand.
I mean, I'm not sure I'm exactly following, Your Honor. I think under the 1981 Act, SEPTA had the ability to initiate the negotiations and then complete the transfer of assets that were contained in the transfer agreement. And that's what happened here. The Section D also provides a mechanism for SEPTA to acquire the same kinds of property rights from Conrail for itself. And that is also what happened here. So our only point is that there's two statutorily approved mechanisms for for SEPTA to get the same the commuter easement from Amtrak, and nothing about Amtrak's contract option could stop the SEPTA from exercising its statutory rights.
It's the other way around, actually, sequentially. First, you have the final system plan. Secondly, you have Conrail negotiating with Amtrak and giving them an option. No question about that. You don't dispute that option was given to Amtrak.
No.
But your argument is when Conrail did that, that was inconsistent with obligations Conrail had to sell to SEPTA or in the final plan, which is sort of strange because you have Conrail thinking, obviously, the final system plan didn't preclude them from giving the option to Amtrak. And then you have the separate argument of the 1981 506 coming along, abrogating, on your theory, the option given to Amtrak. Now, if Congress was abrogating that option, wouldn't it have to be pretty specific? And as I read that language, it's certainly not specific on that proposition.
I don't think it has to be specific at all, Your Honor. It can mandate a process. This is what we want to happen in order to achieve the public goal of assuring continued rail access along the Northeast Corridor and continued viable commuter service. That was the legislative objective, which is clearly within Congress's power. I don't think there's any...
Oh, I don't doubt that Congress could have abrogated the option. It seems to me is you'd have to make it clear. And the language I see in 506 doesn't get you there at all.
Our point is not necessarily abrogation in an explicit sense, but a matter of inconsistency. The Congress set up a process that required the transfer of the asset included in the transfer agreement of the commuter easement to SEPTA. SEPTA and Conrail complied with the statute.
Whoa.
Amtrak cannot assert a private contract right to prevent the execution of a statutory scheme. That's our fundamental point.
Well, it says may, and that gets back to my point. It says may initiate negotiations.
And we did.
But that doesn't give you a right. That depends on what the negotiations come up with.
And the negotiations did come up with a transfer of the commuter easement and did include it in a transfer agreement that was executed by September 1, 1982, that did specify a closing date by December 31, 1982, and it was closed. The commuter easement was conveyed to SEPTA on December 31, 1981 and 82, and SEPTA has used it ever since. Exactly.
Well, there's nothing inconsistent about may initiate negotiations, but runs afoul of Amtrak's option.
And my point is that once the negotiations were initiated as they were, Amtrak could not assert a contract right to prevent the completion of the statutorily mandated or described negotiation and transfer process.
Why don't we hear, no, Judge Rao, please continue.
Just to follow up on Judge Silberman's point, I mean, say I don't think that the 1981 Act gives you any right that is, that supersedes Amtrak's right of first refusal. What is your best argument that the final plan option that you have, the right to acquire or to lease these properties, supersedes Amtrak's easement rights?
Because in the final system plan, which was approved by Congress, Section D gave SEPTA the right to obtain.
But as Judge Silberman points out, the easement comes after the final plan. So as to those two things, how do we choose which takes precedence, your option or Amtrak's option? I mean, to me, that's really the core of this case.
And our option, because it's under Section D, which is part of the final system plan that was authorized, directed to be created by Congress and approved by Congress after it was ratified by Congress. They can Conrail and Amtrak can agree to an option of any scope. And of course, there's any number of other entities that maybe Conrail could have tried to convey to. But that contract could not bargain away a previously granted right of SEPTA to obtain those assets. That's all it is.
Does SEPTA have a right to lease?
Yes.
Does SEPTA have a right to purchase?
Yes.
It's up to them.
Yes.
Conrail has nothing to say.
That's correct.
Why? How do you get that out of it?
Because
may it be purchased or leased from Conrail. That depends on what the negotiations ensue. And indeed, there's a process, is there not, for if there was disagreement, there is a process to decide that with a government agency, right?
Yes, the 1981 Act provides very limited.
No, I'm talking about 75.
Yes, there's a process for resolving those disputes.
And how is that to be done? Is it the secretary of one of the boards or one of the secretaries?
I think these disputes went to the special court.
No, I think it went to the secretary, didn't it? But I'm not sure.
I'd have to. I can follow up.
Let's hear from Amtrak, and then we'll give you some time on rebuttal.
Thank you, Your Honor.
Counsel for Amtrak?
Thank you, Your Honor, and may it please the court. Sean Murata on behalf of the National Railroad Passenger Corporation, better known as Amtrak. Let me get to your question, Judge Rao, about the final system plan. The SEPTA treats the final system plan as if it says that SEPTA has a right to purchase the commuter easement, but that's not what it says. What it says, and it's quoted at Joint Appendix 148, is that you have an option to purchase or lease appropriate trackage rights to conduct commuter operations. But that isn't the same thing as the commuter easement. And it can't be for the reason that Judge Silberman pointed out, which is that the commuter easement post-dates the final system plan. So it could not mean when the final system plan says appropriate trackage rights, it's referring to a commuter easement that does not exist yet. Moreover, the fact that the final system plan says purchase or lease means that you could structure those appropriate trackage rights in any number of different ways. You could do it through an easement, as Conrail and Amtrak agreed to, but you could do it through an operating agreement. You could do it through a lease. And I think that's a key point in this case. SEPTA treats it as if we will not achieve the goals of the 1981 Act or the Reorganization Act, which includes the final system plan, if SEPTA doesn't get this easement. That's simply not true. From day one,
counsel, in fairness, its position is not that the 81 Act specifically says SEPTA gets this, but rather that the choice is left to these commuter authorities. And SEPTA is one, and it came forward. So what I don't understand, and let me ask you to clarify for me, what I've been focusing on is, you don't disagree, do you, that Conrail did not work out as Congress anticipated it would to run an effective and efficient and financially stable rail system?
I agree Conrail didn't work out the way Congress intended it to.
So then Congress decided we need to redo this system that we had in mind. And it passes the 1981 Act.
And what Congress did in the 1981 Act is it set up a system. SEPTA absolutely has the right to say, Conrail, we want to negotiate with you to figure out how to transfer properties to conduct commuter rail operations. And I think maybe you can even read into that a notion of good faith, that Conrail then has to enter into good faith negotiations to effectuate that goal. But what Conrail can't do through those negotiations is sell something it doesn't own, which is a commuter easement free of Amtrak's right of first refusal. Under SEPTA's view, as far as I can tell, that if SEPTA and Conrail had agreed to transfer the Brooklyn Bridge to SEPTA, then their position would be, well, the Northeast Act requires it and no private contract right could get in the way of that. But of course, that's not the law.
In fairness, counsel, go back to the 1976 language, and I want to be clear that is the option Amtrak is relying on. Is that correct or not?
So the option that Amtrak is relying on was the one that was conveyed through the deed that conveyed the Northeast Corridor properties from Conrail.
And is that the language that is repeated on JA 238 to 239?
That's correct, Judge Rogers.
All right, so it says, provided that in the event the grantor, namely Conrail, shall elect to abandon or assign the commuter passenger service easement in whole or in part, other than to a subsidiary affiliate or successor entity, the grantee, namely Amtrak, shall have a first option to acquire such easement or portion thereof at the purchase price of $1. Is that the language of the easement on which Amtrak is relying on?
Yes, Judge Rogers, it is.
Well, the 1981 Act eliminates any option or election. Eliminates any election in Conrail. Conrail has no right of election anymore because Congress has decided Amtrak's not done what we wanted it to do. And so we're creating a new system. And instead, it gives these local authorities the choice. Do they want to do this or not? And if they do, they ought to let Conrail know and enter negotiations. And if they can agree, fine. If they can't agree, then Congress says a property that's at issue will go to Amtrak Commuter, which is an entity created in the 1981 Act. So given that scheme, when the option you're talking about was based on Conrail having an election, that whole notion of Conrail's authority has gone. Or do you disagree?
I think that's where we part ways, Judge Rogers, because
and
Conrail,
what is the basis of your disagreement? Your basis of the disagreement is that when Amtrak, as I understand it, had an option where Conrail elected, and Conrail had the authority to elect. Nevertheless, any right that SEPTA may have obtained remains subject to Amtrak's right with this first option under a different scheme.
So, Judge Rogers, there was an election because Conrail was entered into negotiations. As part of those negotiations, Conrail had to negotiate as to what it would transfer.
When was that election?
The election was in the transfer agreement. It was in the 1982 September 1 transfer agreement. And the
transfer agreements were pursuant to the 1981 Act. That's what I'm trying to, Amtrak isn't mentioned in this regard in the 1981 Act. That's what I'm trying to understand.
Right. So the 1981 Act says there has to be a transfer agreement. It doesn't demand what the transfer agreement, what properties will pass. Though that is the result of negotiations between Conrail and SEPTA. So at the moment that Conrail decided to put into the transfer agreement, and this is Joint Appendix page 319, which is the section that deals with the commuter easement. At the moment that Conrail elected to transfer that, that triggered the right of first refusal, which then Amtrak exercised. It's an election. Now, Judge Rogers,
what I'm trying to understand is if I have an option to buy your house under the property laws of 1976, and then those laws change that says such an option is off the table. Is your point that Congress would have had to have said that expressly in the 1981 Act in order to eliminate Amtrak's option under an election system in the 1976 Act?
What Congress would have had to do in the 1981 Act is to make clear that it was a mandatory transfer of the commuter easement. Congress does not require the commuter easement to pass. Now, Judge Rogers, you mentioned the pass-through to Amtrak commuter, which is, I'll note, it's a separate corporation, but it's a wholly owned subsidiary of Amtrak with all of that entails, including Amtrak's right through its board of directors to control its operations.
But counsel, that's why I asked you what option you were relying on, because I didn't understand, and maybe I missed this, Amtrak to be arguing to this court that Amtrak should be treated as Amtrak commuter.
We're not arguing that, Judge Rogers,
No,
but
right.
what I'm saying is that one of the arguments that SEPTA has made, and I think your questions touch on this, is, well, don't you agree that Amtrak commuter would, a transfer to Amtrak commuter would not trigger the right of first refusal? And we agree with that. A transfer to Amtrak commuter, which we agree is a successor to Conrail as the commuter operator of last resort, and moreover, as a compelled transfer under subsection C of the section 506, that would not trigger the right of first refusal. So the follow-on question is, well, why can't they just get it from Amtrak commuter? And the answer is actually found at Joint Appendix page 341, where back in 1982, the parties did discuss possibly having the commuter easement pass through Amtrak commuter. And what the letter at JA 341 says from Amtrak is, Amtrak commuter doesn't want the easement. Why? Well, because and I'm speaking outside the letter now, I want to be clear. This is my inference from the letter. Is why don't they want the easement? Well, because they're a subsidiary of Amtrak, and so they don't want to do things contrary to Amtrak's preference, which is to have this easement eliminated, which Amtrak has always disliked as a cloud on its title. What Amtrak would prefer, it preferred back in 1982 and it prefers today, is that there simply be a negotiated agreement for appropriate trackage rights, which is either an agreement between Amtrak and SEPTA or set by the Surface Transportation Board according to its powers in the statutes. And that's a key point of this case. No SEPTA commuter will be left on a platform if you rule for Amtrak in this case. Rather, it's just a question of how much is SEPTA going to pay for these access rights.
So my question is, say I agree with your position that the 1981 Act does not give SEPTA any rights. Why? So in 1975, however, there's both a statute and a final plan that's pursuant to the statute that gives SEPTA various rights. How does the easement and the right of first refusal override those statutory and final plan rights?
Because what the statute gives is not a right to an easement. You know, an easement is a particular way of structuring a transaction, which places a cloud on Amtrak's fee simple title to the Northeast Corridor properties. So, in fact, if you look at the back and forth of the letters between Contrail and Amtrak and SEPTA, Amtrak explains the drafting history of the easement and of the right of first refusal that's contained in it.
And of course, that's a very interesting notion that the court should defer to an interested party's interpretation of the legislative history. I mean, you know, some questions, should we even defer to congressional committee statements? I didn't see that as your argument at all.
And it's not my argument, Judge Rogers, but rather Judge Rao's question was getting at, well, the final system plan gives certain rights. Why aren't those rights the commuter easement? And the point I was making was that you could structure the rights that the commuter easement gives in various ways. And so to say they have rights under the final system plan is not to say they have a right to an easement. They have a right to either a lease or to purchase appropriate rights, but it doesn't have to be through an easement. Our position is, and it continues to be, we are happy to negotiate a station lease with SEPTA that contains appropriate rights under the final system plan. And if we can't do that, we're happy to have the Surface Transportation Board set the terms and conditions and price of those rights for us. But it's not an easement.
Then so I understand. Oh, sorry, Judge Rao, go ahead.
Thank you. The final plan may not give them the right to that particular easement, but doesn't it give them a right to acquire various rights that are also included in the easement? So to the extent that the final plan right and the easement are inconsistent, wouldn't the final plan and statutory right of SEPTA trump whatever terms are in the easement?
So we agree that the final plan right, because the easement was meant to carry out the final plan rights of Conrail, which are essentially identical to those of SEPTA. Our point is we don't want this to be an easement because it clouds title, it encumbers our development rights in various ways. Rather, SEPTA has a right to obtain the things that the final system plan gives it. It's not through an easement, it's rather through negotiation of a lease.
Well, but Conrail had the easement, right? So
It did.
the easement is one of the bundle of rights that Conrail had, and SEPTA has some statutory right to acquire, the rights that Conrail had, and one of those property rights was an easement. So I'm not sure why the right of first refusal would trump SEPTA's statutory rights.
Well, because we talked about the 1981 Act, and I think we are in agreement as to why that would not.
Well, I said assuming, but
yeah. So setting that aside for a moment,
right.
The final system plan does not give the right to acquire Conrail's easement. That's the key point.
Why not? Why not?
Because the easement postdates the final system.
Section D says maybe the following rail property. By your view, the following rail properties does not include the easement.
Right. And it can't because the easement doesn't exist at the moment that those words are put into law. Rather, the following properties are appropriate trackage rights. And the appropriate trackage rights can be embodied in an easement, but are not the easement. It can also be through a lease. It could also be through an operating agreement. It doesn't have to be an easement. And I think that's actually that's the fighting point between us and SEPTA in this case, which is that SEPTA thinks it's entitled to an easement. We think SEPTA is entitled to what the final system plan says, appropriate trackage rights and access to stations, but through an agreement or through a agreement imposed by the Surface Transportation Board. So we are not trying to deny the rights that are contained at Joint Appendix page 148. Rather, we're just saying that you're not entitled to it in this specific form. And I understand that might seem pedantic, but it matters quite a bit to these two companies.
In other words, your view is Section D did not include the computer easement for two reasons. Number one, it wasn't in existence at the time. And two, it wouldn't be included in the terminology following rail property.
That's right.
In other words, since it didn't exist, it can't be part of the following rail properties.
That's exactly right.
Is that your basic argument?
That's absolutely right, Judge Silberman.
So if Conrail, after the final plan, were, say, to acquire additional tracks, would those not be part of the final system plan? So, appropriate trackage rights. You say they have trackage rights. What if, they acquired new tracks after the final plan? Would SEPTA not have an option to purchase those or to negotiate over those? I'm not sure why the easement is so different, right? Because they have a right to appropriate trackage rights. Conrail subsequently acquires different trackage rights or some bundle of rights under the easement. It's not clear to me why the final plan wouldn't apply to those.
Yeah, I want you to answer her first question. What about subsequent acquired trackage?
I think in those circumstances, because in those, I want to be careful because what's unusual is that although there are only one track, of course, the final system plan and the various deeds bifurcate the uses between intercity passenger, freight, and commuter. So what's sort of artificial is that Conrail has all the trackage rights in commuter operations.
And so the hypothetical still applies. If they acquire more commuter tracks, whatever.
You're not answering the question.
No, I know. I just want to be careful because I don't want to. These are very complicated statutes, and I don't want to say something in response to the hypothetical that would be inconsistent with something that exists somewhere else in the world, is all. I think they might have a right to operate on those tracks, but again, not by way of an easement. They have a right.
No. I think what my colleague is probing is your response to my question, which was your theory is, I thought this was the one weak point on your brief. Your theory is that Section D only refers to existing trackage rights, not the computer easement, for two reasons. It doesn't refer to a computer easement. I'm not sure why, if the commuter easement were in pre-existence at the time of Vital D, it wouldn't cover it. But let's assume, let's keep in mind it comes in afterward. Then Judge Rowell asked, well, suppose there was new trackage that didn't exist at the time of the final plan. Wouldn't that new trackage be covered?
Oh, I think the question has now clicked for me, and I think the answer is found at Joint Appendix 148. It's appropriate trackage rights for the operation of commuter services on all rail lines used by Amtrak on which there are present operations of commuter trains. So I think the fact that it's present operations of commuter trains would suggest that perhaps later acquired track would not fall under the final system plan. Because it not only is talking, there's not only the temporal issue of what rights exist at the time of the final system plan, but the final system plan itself refers to the present operations of commuter trains as of the moment of the final system plan. So I think the final system plan itself also gives an indication that it's the rights that are in existence as of that moment.
It doesn't use the term rights, it uses the term property.
Rail properties, and I believe rail properties is defined in the 76 Act as both property and rights to property.
I see. I see your point.
Well, I mean, it doesn't just limit it to the present operations on which there are present operations of commuter trains by a transportation authority, or which are useful for operation of trains by a transportation authority. So, I mean, I don't think it's limited temporally necessarily. Or am I reading that incorrectly?
So there is a discussion of used or useful, which I guess might suggest that if it's sitting in a warehouse somewhere, but is nonetheless found to be useful, there is a right to it. But I think even then we're winding back to the notion that there's not a right to acquire it, there is a right to purchase or lease it. SEPTA thinks that it's at SEPTA's election, but that's a statement found nowhere in the final system plan.
Well, so then is your position, say the easement predated the final system plan, then would SEPTA have a right to acquire the easement particularly? Because you're suggesting that easement, you have two arguments, I guess, as I see it, right? One is that the easement comes after the plan and therefore is not covered by it. And also that the easement is not the same as trackage rights. So what if the easement came before the plan? Or if it pre-existed the plan?
The easement pre-existed the plan. And I want to answer the question directly, then explain why I'm not sure the premise works. But I want to answer the question directly first. The easement comes before it, and I suppose you could say there's a right to purchase or lease it, but that still doesn't mean it's at SEPTA's election as opposed to anyone else's. So I think then we would be back to the same argument we had under the 1981 Act that says the choice between purchase or lease is at Conrail's election. And because it's at Conrail's election, it triggers the right of first refusal. Now let me answer why I'm not sure the premise works, which is that the commuter easement, even though it's drafted as an easement, was meant to carry out the final system plan, and so therefore comes into existence as part and parcel of the Act and of the final system plan. So it's always going to postdate the final system plan. I'm just not sure the hypothetical could exist. And that's one of the key points, which is although it's written as an easement, really what Amtrak and Conrail were trying to say at the time is, all right, you have certain rights in the final system plan. Here is how we have decided to embody that right, but we're only willing to do it with respect to Conrail. And so if Conrail tries to give it to someone else who's not a subsidiary, successor, or affiliate, we Amtrak want that back. And then we're going to engage in purchase or leasing on our own terms with that new entity who is claiming trackage rights under the final system.
I understand that's what Amtrak wants. You've said a few times, but it's not clear that that's consistent with the underlying final system plan. I mean, that may be what Amtrak hoped to do, but it's still not clear to me why that easement would undermine the rights that are in the final system plan that SEPTA has.
I'm not sure that the easement undermines the final system plan rights. I don't think that the final system plan gives SEPTA the unvarnished right that it thinks it has. Because to overcome the word elect in the option, it has to be compelled. And what SEPTA can't do is say, what is compelling the transfer of this easement as opposed to anything else? Because they equate their statutory right of access to the Northeast Corridor properties with access to this easement. And I don't think they can point to anything. And in fact, at page 41 of their brief, they say, well, you shouldn't read an implication from a lack of expressiveness into these statutes. But our position is, unless they can point to something in the final system plan or the 1981 Act that requires the transfer of this easement as opposed to merely appropriate trackage rights, then they can't overcome the word elect.
Is it clear the term appropriate tracking rights is different from the easement?
The easement includes appropriate trackage rights. The easement is not itself the appropriate trackage right.
Where do you get that?
Because the easement itself says...
So where do you get that out of the documents?
So
I thought that was a point on your brief that was a little weak.
Well, I get it from the easement itself, which says that the purpose of this easement is to carry out the purposes of the 1976 Act. So, and this I think gets back to what I've told Judge Rao, which is that the easement is one way in which you can embody the appropriate trackage rights, but it is not the appropriate trackage rights. And I don't think SEPTA can point to anything that says otherwise. There's nothing in the final system plan that says Conrail gets an easement.
No, my question is, what do you point to exclude commuter easement from the term appropriate trackage?
Because it's appropriate trackage rights for the operation of commuter services on all rail lines used by Amtrak, and then there's a bunch of language that follows it. Nothing in that requires an easement. Nothing.
Well, I guess your thought is that an appropriate trackage right, it's at Amtrak's election whether they give an easement or some other, embody it in some other legal way.
Through a process of negotiation, absolutely. And I think throughout all of these statutes, the 76 Act, the 1981 Act, Congress used the language of negotiations. Because although Congress was trying to reorganize the passenger rail in America, they were attempting to do it through a group of at least nominally private for-profit corporations. Now, of course, all of these corporations were in many ways reliant on the government for their operations, but Congress wanted this to be done through systems of negotiation and planning and working them out among the parties. So it did not say, you must give them an easement. It said, you must give them appropriate trackage rights, and then has silence following that. And into the silence comes negotiation.
So your view is that nothing precludes Amtrak from embodying trackage rights to Conrail in an easement, but then when SEPTA comes along,
it doesn't have to do it the same way.
Doing it in a different way.
Right, and that's why
Amtrak's choice.
That's right, and that's why it wrote in the option into Conrail's easement, which what in effect it does is it says, all right, Conrail, you get an easement, but you can't give this easement to someone else except a successor, an affiliate, or a subsidiary. That entity has to come along and work with us separately.
So how would that work practically, right? So if SEPTA has the right to acquire these trackage rights from Conrail, and the way Conrail has these rights is through an easement, what can Conrail give to SEPTA that's not the easement?
I think it could.
Right, because they could go, because they have the right from Conrail, right, not from Amtrak itself. And what Conrail has is the easement. So what would SEPTA be able to get if it couldn't get the easement from Conrail?
Well, but I think that it could get a lease, I think, over those rights. It could have a right to access perhaps through the lease, but to the extent Conrail agreed to the option and it then merges in back to Amtrak, what then comes about is you have to approach Amtrak for it.
You have to what? I didn't hear the last.
You have to go then back to Amtrak to get the appropriate trackage rights.
So you're back to negotiating with Amtrak is your position?
Yes, and it's not as if
no matter what your position is, no matter what path you pursue, no matter what Congress says, You have to negotiate with Amtrak.
No, Congress could say, the easement must be transferred or you're entitled to trackage rights in an easement. But Congress didn't do that. So what you're left is with negotiating with Amtrak. And of course, Amtrak can't be obstinate because there's always the Surface Transportation Board to break the tie or to break the impasse.
Anything further?
Does the whole case come down to the question whether trackage rights includes an easement?
I'm not sure if the whole case comes down to that, Judge Silberman, but I think it's one of the elements of the case.
No, but my point is, if an easement is included within the term trackage rights, don't you lose?
I think if that you find that this easement is within the term trackage rights, then I have a much harder time. Unless the court has further questions.
Thank you. All right, counsel for SEPTA.
Thank you, Your Honor. I want to pick up on that last point because I think it is key. The commuter easement are the trackage rights. They are the rights to use the tracks that Conrail created and reserved for itself when it conveyed the rest of the fee interest, along with the freight easement, by the way, when they conveyed the fee interest to Amtrak. Those are the trackage rights. They are the appropriate trackage rights because that's what Amtrak and Conrail designated as the appropriate trackage rights. It makes no sense to say that we can't get the same rights, SEPTA can't get the same rights that Conrail had. That was the point of the transfer. That was the point of Section D. And when I say transfer, I mean the 1981 statute transfer. And that was the point of Section D. And at the time that Section D was written, there really weren't any trackage rights as such because that was before the division of property between the various railroad entities. So it was by definition forward-looking, and by definition gave the commuter authorities the right to obtain the appropriate trackage rights. And I don't understand how you can say that the appropriate trackage rights aren't the very same embodiment of the statute of the easement, right, of the rights in the easement.
Surely there are other trackage rights besides the easement.
There are.
To Mr. Murata.
And as Mr. Murata conceded, trackage rights could take the form of an easement, and they did. That is how the trackage rights were embodied.
So why shouldn't Amtrak have the ability, though, to decide that it will give over appropriate trackage rights in some way other than it?
Because and really this gets back to the 1981 Act. What we're talking about here is continuity of service under a revised scheme with Conrail left the picture. In the original final system plan in 1976, the idea was that Conrail will do it. Here's all the rights that Conrail needed and that were granted to it and that needed to do its service. In 1981, Congress said all that needs to switch over to either a local commuter authority or Amtrak commuter at the commuter authority's election. SEPTA elected it, and it said, we want the same things that Conrail had, and Conrail gave those to them.
Now, counsel, you agree that last clause, is that in the statute?
I beg your pardon, Your Honor, I'm sorry.
No, I mean, you said you want continuity, so the local SEPTA can negotiate with Amtrak. That's all it says, right?
Yes, well, no, earlier, and I think it's section 1136, and certainly in the, I'm sorry, I didn't bring my addendum up, but in the initial section, it says the goal of this is to terminate Conrail's commuter operations and transfer it to an appropriate commuter authority. And the process that it set up to do that in 1137 is how it affected that. And as we talked about before, through the process that at SEPTA's initiation, the parties agreed to designate the commuter easement and other assets for transfer to SEPTA to allow SEPTA to continue the same operations, which is what Congress ultimately wanted, was to continue commuter operations under a different operator than Conrail.
So did you misspeak in referring to 507? You meant 506? I don't see 507 in your statutory addendum.
I'm sorry, I meant 1137.
You meant
1137 when I was talking about the transfer.
Where is 1137?
On page 76.
So that's section 506.
Yes, I'm sorry.
Yeah, let's let's refer to the same thing the same way for just help us understand what's going on here.
The basic
Okay.
point, and I think my basic point is that the point of the 1981 Act was to effect the transfer of Conrail's commuter operations to local commuter authorities if they so elected. And SEPTA did so elect. SEPTA and Conrail agreed to the properties to be conveyed, which included the commuter easement, which makes perfect sense because SEPTA was taking over the exact same operation as Conrail to effect the same purpose that Conrail was created to do, which is to provide commuter rail service. There's no reason why Amtrak and SEPTA need to start all over when this was just an assumption of interest. And I want to make another point because it relates back to the option terms itself. Mr. Murata agreed that Amtrak commuter was considered Conrail's successor. And yet the 1981 Act refers to Amtrak commuter and local operating authorities like SEPTA as equals. If Amtrak commuter is a successor, in this case, so must SEPTA be considered a successor because it succeeded to Conrail's operations in exactly the same way that Amtrak commuter would have. And as far as for the election point, I think the broader point here is that Conrail was being put out of business.
I just have, or at least for my part, just one final question. Can you point to something in the statute or the final plan that precisely says that SEPTA, with respect to acquiring these trackage rights, sort of gets to step into the shoes of Conrail as opposed to negotiating with Amtrak separately?
Well, it's that in section 506 in the property transfer.
Well, no, we're not talking about the 1981 Act. I'm talking about the final plan.
Oh, I'm sorry. In the final plan.
Or in the statute that,
Well, it would be section D, which allows SEPTA to acquire the appropriate trackage rights and use some property interests in the stations to carry out the commuter operations. And in the final system plan, of course, in that case, they weren't contemplating the elimination of Conrail service and succeeding to that by the local commuter authority. So it's a different context. But I think the point is that, and I want to put a little bit of context on this. At all times, SEPTA was paying Conrail was paying at the time Conrail for the service. It wasn't being offered for free by Conrail. So when SEPTA takes it over, it's really just taking over operation of its own service, as opposed to contracting out for it with either Conrail or as an option with Amtrak commuter. So it always was SEPTA's service. It was a question of who was actually operating it. And in the 1981 Act, Congress gave the option to operate it not to Conrail, but to either SEPTA or, at SEPTA's election, Amtrak commuter. I think
one more question I have, make sure I understand. Your position is the transaction between Conrail and Amtrak, whereby Conrail gave Amtrak Conrail maintained an easement with Amtrak getting the option. Your position is that was illegal.
My position is there's two positions. One, under the facts, their option was never triggered because Conrail did not make an election. And,
I know I'm not very impressed with that argument.
And secondly, that the option was unenforceable as against SEPTA because SEPTA was acting pursuant to either Section D and or the 1981
Well, it
Act.
would have been true. It would have been unenforceable against any computer company, right?
Well, in this case, I
So
suppose
basically, it's an illegal option.
I could imagine. I'm not really fundamentally. I don't disagree with that. I'm just saying there could have been a particular purchaser who, for whatever reason, it would not have been contrary to Congress's plan. I don't know what that would be. But yes, the option was unenforceable, especially if SEPTA wanted to acquire it, the easement.
Conrail plays an interesting role in this whole process. They seem to be on all sides of everything.
Well, Congress put them in the middle, and then Congress took them out and left it, and then it said, SEPTA, you take over from Conrail. And that's exactly and all we really are trying to do here, and to continue the service on the same terms. Thank you.
All right, thank you, counsel. We'll take the case under advisement.
Can I get a cup of coffee?
Courtroom deputy,
Yes, Judge?
are you going to call the next case?
Right. Case number 21-5080, Association of American Physicians and Surgeons, Inc., and Caterina Varelli, individually and on behalf of all others similarly situated.
Excuse me a moment. Judge Rao took a brief recess. He walked out.
Sorry, I didn't know that.
I realize that.
So let us know when she's back, if you will.
I certainly will.
Not a-
As far as I'm concerned, yes. You both have to use masks, or did you get your shots? Your test. Did you get your test?
Yes.
Well, you can take the mask off.
Thank you.
Preserved it.
I'm assuming yes.
Judge Rao, are you ready to proceed?
She came back in.
Thank you.
All right,
Case
courtroom
number-
deputy, will you please call the second case?
Case number 21-5080, Association of American Physicians and Surgeons, Inc., and Caterina Varelli, individually and on behalf of all others similarly situated, appellants, versus Adam Schiff in his individual capacity and his official capacity as a member of Congress for the 28th Congressional District of California. Mr. Joseph for the appellants, Mr. Tillman for the appellate.
Counsel for appellants, please proceed.
Lawrence Joseph for the appellants. May it please the court.
May I ask you to raise the dais so that your voice can be heard?
Yes, I had to figure out how.
The courtroom deputy is supposed to explain that.
It is as high. It is as high as it can go.
It's as high as it can go, Your Honor.
Okay.
I'll lean forward, perhaps. Lawrence Joseph for the appellants. May it please the court. My conference with opposing counsel was that there was a decision yesterday, a 70-page decision. It appears involving presidential records and Committee of Congress.
You mean the decision by this court?
Yes, correct. And I have not, I've read the first page or two on my phone coming in this morning. It seems that it's not relevant. So if anyone on the court
believes it is, I'd request a chance to review that before responding. But that involved a committee of Congress tasked with investigating and reporting. This involves an individual member, so I don't think it's relevant. And I just wanted to say that I had not had a chance to read that.
I haven't either. Does it even relate to speech and debate or a standing?
Well, it relates in part, I suppose, to the power of a committee of Congress and the implied investigative powers. I honestly don't know, Your Honor, if there's anything in there that's relevant.
I don't think so.
Okay, great, wonderful. What this case does relate to, and it was dismissed on immunity and Article 3 standing grounds, is the extent to which an individual member of Congress outside the committee structure can interfere with rights of private parties interacting with third parties. The three sort of important things at issue here are standing, immunity, which has two components, the speech or debate clause and also the Federal Tort Claims Act. And then the third important issue is the power that the district court for this district was given in 1801, drawing on the common law of England, or Maryland, I should say, as it existed, which was then pretty much close to the common law of England. And that continued going forward. So there's
Counsel, I advise you to start with the standing issue and the speech and debate, because those are the most important questions we're facing.
They are, but I believe the third also relates to standing, relates to immunity, because shortly before the founding of this nation, and therefore before Maryland came into existence and this common law power was given to the district court here in 1801, a colonial governor of the crown was held liable for a tort, malicious prosecution, assault, false imprisonment. And that was done through the common law court, the highest common law court in England, the King's Bench. And that same power was given to the Maryland state court system, which was given to the DC court system.
Mr. Joseph, can you cite any case since 1970's Reorganization Act in which the district court has used this historical common law power?
Well,
so that's almost 50 years, more than 50 years.
Well, the Gaiman, Heckler versus Gannon refers to mandamus, and it cites this particular common.
All district courts have mandamus.
Oh, no, the Gaiman court distinguishes the 1361 mandamus, the Venue Mandamus Act from, if you go back and look at Gaiman, and we cite this.
Is your serious argument that Article 3 is not the limitation on a federal district court in this circuit?
The district court has the power to create a tort against an officer of the national government.
That may or may not be true, but are you suggesting that the district court is like the Supreme Court of Massachusetts? It's not bound by Article 3?
It has the power to create torts. It's, of course, bound by Article 3 standing, yes.
Yes, then why don't we go to the standing and speech and debate? Because we don't have to even, if you lose on those, we don't even have to get to it.
Well, they do animate the standing inquiry because for several reasons. One is if a tort were created for just this kind of interference, certainly there are concrete things, information,
you
revenue.
You still have to have injury in fact, causation, and redressability.
Yes, counsel, that's the third time you've been asked to address standing. Why don't you?
Thank you, Your Honor. So the concrete injuries here are loss of revenue, loss of information, inability to associate, reputational injury, contracts that were modified. Those are all concrete.
Loss of what?
Loss of
income?
Yes, we've mentioned that, yes.
How much?
That was not quantified.
So we have no idea whether that's a penny or more. What's your second loss?
Well, we're being branded as anti-vax in this instance.
Who's branding you?
Both the defendant and I suppose also the third-party tech companies But we'd be willing
Where did he brand you as such?
in his inquiries to the tech companies and in the background negotiations that happened before those were released.
His inquiries to the tech companies do not even mention you or your organization.
That's correct.
So that doesn't work for you. And what's the background? No, I mean, counsel, let's be clear. What's the background discussion by the chairman?
I'm sorry, could you repeat that? I didn't hear you.
What is the background discussion by the chairman on which you are relying to show
the chairman
you have been branded as anti-fax?
The interaction between the congressman's office and the companies with which he was.
What specifically, counsel? I didn't see anything in your brief. He's inquiring of these companies. He doesn't mention you or your operation or anything.
The allegation in the complaint is that they worked behind the scenes to develop a position, and then they issued this press release announcing that
that's going to causation. Let's assume arguendo for purpose of discussion, because you have injury in fact if your voice is muted, if your ability to speak is somewhat diminished. That could be injury in fact, but I don't see for the life of me how you get causation.
Well, again, we would be willing to bring in the third-party companies as defendants.
Well, no. Your case is before us now. What is your theory of causation?
That this was the intended result of negotiation.
What was?
The elimination, the deplatforming of. So there are these search engines that used to develop a reliable stream of traffic to our sites. Google is one of the bigger ones. DuckDuckGo, I think, is one of the smaller ones.
So the social media cut you down, right?
That's right.
But what's the causation?
The causation is
that may be the injury. In fact, where's your causation?
The negotiation between the congressman's office and the tech companies.
But the congressman never even mentioned the tech company.
He did communicate with the tech company.
I never mentioned you.
Yeah, well, we are. So we're not alleging, I guess, defamation in that he said.
No, there's no connecting link.
Well, the connecting link is down. We have what the complaint alleges is good information presenting all sides of the debate on vaccines. Anything that questions the dominant narrative from Representative Schiff is considered anti-vax information, and you can't listen to that. So we are maybe we weren't the intended victim.
You have a third party who arguably caused you injury, but there is no connection to the defendant.
The defendant sent his letters. We say they negotiated beforehand, before they were released, and then immediately thereafter we had a plummet. I think we think that there's enough there for Article 3 standing and causation and
how about redressability?
Well, redressability, if there's two things, I suppose. One, we could get damages. That's a possibility. It gets to the immunity question, which we haven't discussed yet. Two,
damages for what particularly?
Abusive process interference with, constitutional
process interference with what?
With First Amendment rights. So I'm trying to retrace my thoughts. So the immunity thing.
In other words, anytime a member of Congress writes a private entity about a particular subject, of interest to your association. That's enough for Article 3 standing?
Well, this was a little bit of an extreme example that I mean, the answer to your question may be yes or no, but here what we have is very targeted to deplatform. So it's not just writing a letter. The goal is to sort of shut down information of a disfavored variety. And yes, the fact that he's a federal actor makes that problematic, whereas if they were just private actors conspiring, that would be a different thing.
So you would just cut back on Congress's ability to inquire. And we haven't gotten to speech or debate yet, but you're just saying he's just a single congressman, although you sued him as chairman, right?
No.
You sued him individually?
Yes.
You're seeking damages against him individually?
Sorry, let me clarify. We sued him. We didn't sue him in his capacity as chairman of the Intelligence Committee. We sued him as in his official and individual capacity. His official is as a member of Congress. That, you know, if you want to infer into that.
But you're going after him as an individual as well?
We named him individually as well. And for abuse of process, if indeed that's what he did. If what he, I mean, again, he is not Congress. He's referred to him several times, Your Honor, as Congress. He is one member of one body of the House. I'm sorry, one member of one body of Congress, the House. He is not, he does have an interest, I suppose, as indicated by prior years in which he got issued a sort of an identical sense
I guess, you know, back to Judge Silberman's question, redressability.
So damages or an injunction that would take away, again, he's publishing on social media, which under Proxmire and McShirley, he's outside of the realm of Congress. If we get,
let me stop you for that a moment on that. You do mention letters he sent from Congress, but that has nothing to do with your gravamen of your case. Your gravamen of your case, I gather, is that the defendant, by sending letters to social media, implicitly threatened them. Isn't that correct?
in truth, I suppose we don't know if they were willing co-conspirers or whether he coerced them in a threatening way and made them do it. I
thought that's I understood your complaint was that there was a threat, an implicit threat.
We allege that he coerced them into this,
okay.
Yes.
So the outside communication has nothing to do with your case.
The publication on social media by the congressman. So I'm sorry, social media comes into play here in two ways.
No, I know how social media comes into play. That's your third party factor. But you're absolutely right about the Proxmire case indicating that communications outside Congress are not covered by speech and debate. And you do have communications, but they're not relevant to your gravamen of your suit, which is the threat.
Well, but he also goes on social media and brags about this. So this is essentially posturing. I mean, again, the way this
bragging about it is not part of your loss and not part of your injury. Your injury is that you were kicked off the social media.
And branded, I mean, to the extent that reputational injury is part of it, the broad brush of calling.
Because of being kicked off social media, you're hurt.
Okay.
That's your injury.
There's a reputational injury, but yes, that's the primary one.
Okay. So all I'm trying to say is the outside communication is not really relevant to the key of your lawsuit, which is the threat, the alleged threat that his communication with social media creates.
Well, I would disagree because if a body of Congress wants to enact a law about something sort of behavior being inappropriate, they can do that and it has to get signed by the president or overridden. But this is just one member of Congress saying bad things about something and then going online in his social media accounts afterwards and saying bad things about a particular line of thought, and that line of thought then being beaten down, suppressed from the public debate.
Expressing
is your case Is your case a defamation case?
No, there's defamation injury, and we wanted to be. He's put his.
I didn't see that in your complaint.
There's a reputational injury that's cited in the complaint. If you want to.
Reputational injury because of being kicked off the social media.
I'm sorry. It's being called anti-vax. The complaint says that means unintelligent or uneducated, and what it really means is someone that disagrees with the representative's narrative on whatever he thinks is right about.
Counsel, the facts of your case were as follows. You put things on social media, and your statements are, we have questions about these vaccines, but on the one hand, there's this view, on the other hand, there's that view. And so in your opinion, you're not pro-vax or anti-vax, all right?
Correct.
So the fact that the congressman writes letters saying to the tech companies, I'm concerned about misinformation appearing. This doesn't have anything to do with you.
But it resulted in our.
In my hypothetical.
I'm sorry.
So now you say, well, if we say to the congressman, you're liable in damages, and suppose he pays the money, how does that stop Google and everybody else where you made money before from keeping you off?
Well, that is a form of redress if the question is Article 3 standing. But the other,
you're trying to, you base your injury on what happened as a result of these letters, where the letters said nothing about you in terms of your association.
Right.
All right. So all I'm getting at is how is your injury redressed by making a member of Congress pay damages? Because the people or the entities you want to carry your message have decided they're not going to carry it anymore for whatever reason. They had a change in the board of directors, they had a change in policy. They're just not going to carry your messages anymore.
The other, and this goes back to Judge Silberman's question about redressability. I said there were two. I mentioned damages. We went off on the recent discussion. The other is that we could get his statements outside of Congress, so his social media statements, taken down. That's a form of equitable relief. Doesn't even implicate the Federal Tort Claims Act, that would leave us free, as far as standing and first-party injury are concerned. That would leave us free to negotiate with the Googles of the world. Now, you may express.
So let me understand. What would the court order say about his outside statements?
You said the four corners?
No, the court.
I said.
Judge Rogers asked, what did the court below say about that?
The court below, I don't believe addressed, I may be wrong here. I don't recall how the court addressed the idea that there's a first party injury by virtue of interacting with the vendor-vendee relationship, and just the redressability would exist under.
I think the question is, what would our court order say? With you.
Oh, well, it would say, so it would say that this is improper meddling, Representative Schiff.
Improper meddling? What is? Asking questions of tech companies?
Well, you're taking the surface of what's available.
I'm just asking you, counsel. It's not a letter that says, take down this website, all right? It says, I'm concerned about misinformation being sent out. And the tech companies said, we're not doing that, you know, end of discussion. Or the tech company could say, we're not going to carry certain websites in the future. And what does our order say to be sure that your website is not taken down?
Well, the availability of declaratory relief or injunctive relief about the inappropriateness of to the extent that we can prove that Representative Schiff worked behind the scenes, and this wasn't really honest fact-finding, which is what we allege. We allege it was kabuki theater. He arranged the result with them, then sent a letter, and then, hey, presto, they did a press release, and then he
But,
did
you know, in a complaint, you are saying to the court, you can prove this. And you've made allegations. But now on the motion to dismiss, what did you say in response?
I don't believe that this issue came up particularly. It was, I think we were given short shrift. And I think the court is supposed to assume the truth of our allegations and didn't in this respect. But again, so if we remove the thumb on the scale that we say Representative Schiff is trying to put, then we'd be free to win or lose. And that's FEC versus Aikens. In our negotiations without the impermissible federal interference.
Mr. Joseph, I mean, members of Congress frequently make speeches or send letters on all number of topics, which may affect private behavior, which then may have an effect on a third-party organization. Are you aware of any case in which a court has found that to be an injury for the third party, where a member of Congress's actions have, arguably created an impact that had an effect on a third party? I mean, because this is happening every day, right? Where members of Congress are speaking out on various.
Well, it shouldn't be in this sense. This is someone basically as a lone wolf.
Counsel, isn't your best answer the Proxmire case?
Well, there's the Proxmire case. There's also Block versus Meese, which was the Department of Justice, but it wasn't a member of Congress. But they were labeling someone as propaganda. Here, we're being labeled as anti-vax and idiots, and anti-science, which is odd because my clients are the scientists, not the representative. And so, again, in Block.
I understand that, and I understand the political harm that you are alleging, but in what way is it an Article 3 type of injury?
In the same way in Block versus Meese. I mean, in other words, if you're in Block versus Meese, the label was propaganda, and if you were associated with the propaganda, you were a bad person. And the court, this court, distinguished between legal causation and de facto causation. Legal causation went to whether you could prove damages or not. All you needed for standing was de facto causation, which is if people incorrectly believe that the DOJ tried to argue, but propaganda doesn't mean what they're saying it means, but people are taking it that way. And here it's even worse because they were still able to reach their customers. It was the 80s. Now we don't even, they have severed the connection between us and the people with whom we were communicating. So we don't even get to the question of whether the consumer thinks the anti-vax label is improper and therefore they should dissociate with us. That was the issue in Block versus Meese.
But I'm still trying to figure out why the community, I grant you under Proxmire, the Supreme Court said communications directed outside of Congress may not be covered by speech and debate. But I still don't see why that is relevant to your basic gravamen of your case, which is an implicit threat that Congress makes, and thereby the social media kick you off. So the communication outside doesn't seem to have particular relevance. You're upset about being kicked off.
Well, I mean, to some extent, your question recalls Franklin versus Massachusetts, if that's, I might have the order wrong, but the idea there was, how is this, I can't order the president to do something, but just a court ruling saying what the law is would be meaningful. In other words, saying you can't do this under the First Amendment. That would stop.
No,
That would
I was just dealing with your communication outside.
right. And if that's impermissible,
But I
and
don't
we can
see that
strike
that's
it.
particularly relevant to your case.
Well,
You're
again,
not making a defamation argument, as was true in Proxmire.
right. That's true. We're not making a defamation argument.
So
We're saying
your basic argument, I understand it, is there was an implicit threat when the congressman sent a letter out and the third party reacted to that implicit threat. That's your allegation, isn't that?
that is one half of it. The other side of that coin is that they're working together to suppress speech.
Come on, that's the legal conclusion. I'm talking about the facts from your allegation. I understand your allegation. All I'm trying to say, it doesn't seem to have anything to do with public statements. It has to do with pressure on the social media companies.
That is a component, and then he's gloating about it afterwards. And if
whether he's gloating or not, that's not relevant. Your only concern is that he allegedly knocked you off social media.
okay. But the question is the extent to which judicial power can touch what he's doing, either before or after, under
Well, there's several problems. The first of which, there is no direct threat against you. Not at all. You're not even mentioned. So causation seems to be very weak. Very weak. There's nothing you allege that leads us to conclude that your allegation is that there was a threat and therefore they folded. You didn't say that.
well, and then the First Amendment context that we're in, overbreadth is another concern. In other words, if someone's shooting out, normally if they were saying that you were doing something improper or whatever, I won't come up with a colorful example, but that might be defamation. But if what you're doing is saying a whole group of thought is improper for public discourse and shouldn't be online, that is causation.
I don't have any further questions.
Okay, why don't we hear from counsel for appellee?
Good morning, Your Honors. Todd Tattleman for Congressman Schiff. I'm the Principal Deputy General Counsel for the House of Representatives. I want to start, I think, where all three of you already are, Your Honors, which is there's an 800-pound gorilla in the room here. There is an absence of standing here because whatever injuries these plaintiffs may have suffered, and I'm not going to concede that they've suffered any legal injuries.
Why wouldn't a diminution in their ability to speak be as much of an injury as turning off the megaphone from somebody speaking in Lincoln Park?
If there were an actual diminution, Judge Silberman, I think you'd be right, but there isn't one here. They haven't alleged one here.
They haven't alleged their voice has been muted?
They've alleged that their internet presence has been diminished, but they're still able to publish.
That's an injury in fact, seems to me. Although the district judge didn't think so. But I have more problems with causation and redressability.
I was just about to get there, Your Honor, which is to say, even if you assume that there is an injury in fact, the problem here is that Mr. Schiff, the congressman, is the wrong party to be the defendant. The proper parties here are the tech companies, the social media companies.
Suppose the letter that Congressman Schiff sent to the social media companies said, I want the defendant off social media, and if you don't accommodate my views, God help you on Section 230.
If that were what a hypothetical letter says, and it's certainly not what the letters Congressman Schiff sent in this case said, but if that were a hypothetical letter sent, then I think I would need to shift my focus and talk to you about the fact that he would still be immune under the speech or debate clause, because that official letter would potentially implicate other things, particularly the legislation necessary to enact changes to Section 230. But right now, we're only talking about standing, and under the standing doctrine, as this case has been presented, first of all, there was no...
Well, there would be causation under that, my hypothetical, would there not?
I would certainly challenge that there would be causation, yes.
Why? Why wouldn't you concede there was causation?
I wouldn't concede it, Your Honor. I would suggest that there was still an absence of causation because the tech companies still needed to effectuate that. His injuries, his client's injuries are caused by the tech companies. Their actions are the proximate cause of the injuries, not the letters.
The congressman could, with impunity, threaten the tech company.
I wouldn't say with impunity, Your Honor. He could certainly make his public policy position well known. He could certainly advocate for a position that says, because you tech companies have failed to do things that I find, or other members like me find unacceptable, we are going to consider legislation that would remedy that. He may do those things.
The question is whether that might still be covered by speech and debate, but wouldn't causation be established?
Again, under your hypothetical, Your Honor, I think that you're assuming that the link follows, that because he makes the threat, the tech companies do what he wants them to do, or they refuse to do it, and Congress passes a change in the law. Either way, I think their causation link is problematic because the independent actor of the tech company still gets to make a decision. Facebook could decide, we're perfectly comfortable leaving these people on our platform, and we're perfectly comfortable with whatever Congress comes up with.
Normally, we conclude if somebody puts a gun to the hand of a third party and says, don't do something, causation is established.
Under certain circumstances, I would agree with that, Your Honor, but here I don't know that necessarily follows, because these tech companies are motivated by a tremendous number of factors, none of which can be established, in your hypothetical doesn't necessarily establish that it would be Congressman Schiff's letter or his threat, express or implicit, that would lead them to take the actions that cause the injury. It might, and if it could be established that it did, I would concede that causation was there, but simply on its face, I don't know that that's sufficient, and I would certainly suggest that it isn't.
And would such a letter be covered by the speech and debate immunity?
I would want to see I would want to probe more details into what exactly the letter says. But hypothetically, a letter that suggests that unless a private company does certain things that Congress finds acceptable, Congress is going to consider changes in the law and lays out what those potential changes would be. I would think we could make a very good argument that such a letter could be covered under the speech or debate clause. There's a line there and it could cross it, but
Congress has the authority to direct private companies to take action.
Not direct.
A single member has the ability to do that?
No, Your Honor, a single member doesn't have the ability to do it, but
you're saying that would be a legislative activity. Telling a private company what to do would be a legislative activity within the scope of the speech and debate clause?
I'm suggesting that it could be a legislative activity depending on how it was phrased, depending on the rest of the context.
Directing private companies what to do is a legislative activity?
I don't think it would be directing them, Your Honor. As I understood Judge Silberman's hypothetical, it was a suggestion. It was using the political tools and the leverage that they have to change the law to effectuate a result. Again, I think there is a line there that and this is why I hedged at the beginning, which is there is a line, and I'm willing to concede that. But I don't know that merely suggesting that that a member could suggest to a group of companies like this, that unless you all companies make significant changes to your operations or your behaviors, that Congress is going to consider legislation to make them for you. I do think that potentially would be protected under the speech or debate clause. How you communicate that, the language that gets used, all of those things would come into play in that analysis. But as a hypothetical matter, yes, I think that potentially could be covered.
Could there be constitutional problems that would circumvent the speech and debate clause? Are you familiar with Pillsbury case in the Fifth Circuit? From
the Fifth Circuit, Your Honor, yes, where the members in that case interfered with the decision makers at the regulatory agency.
Right. And that was
but here
that would violation of the Constitution.
That was found to have been a violation of due process for that company.
Yes. I'm glad you are familiar with the case. But would not any threat a congressman issued against speech raise First Amendment questions, just like due process questions?
Yes, it would raise those questions, Your Honor, but the Supreme Court's jurisprudence and this court's jurisprudence, and I would point you to the most recent example being the case Rangel versus Boehner, has said very clearly that the mere allegation that something violates a constitutional right or even a rule of the House isn't enough to get around the speech or debate immunity. So yes, it would raise the questions, but I still think that the immunity could hold.
Well, under any circumstances, no matter how significant the threat was to stop speaking?
Again, I want to be careful, very careful here, because I don't want to suggest that there are absolutely no circumstances upon which, but I think you have to get very, very far down the line here. And I'm not sure that the hypothetical circumstances that we're talking about get that far down the line. Hypothetically, they could. I think we could come up with potential examples between us that might reach that. This case certainly doesn't come anywhere close to it. So even if there are examples several steps removed from where we are here, this case isn't that case.
I'll just ask you to clarify something on the sovereign immunity point. Is your position that if this is only sovereign immunity that is covered by the Westfall Act? Or are you suggesting there is some broader sovereign immunity that is not statutory? I just want to be clear about that.
We think we've been very clear in our papers that it is the first one, the Westfall Act. Okay. It's the sovereign immunity that has been extended by Congress through the Westfall Act and the amendments to the FTCA in 1988.
So you're not claiming any non-statutory sovereign immunity?
No, Your Honor, not here. I'm happy to answer any other questions, Judge Rogers, if you had any, or anyone else. If not, I think it's very clear the district court's opinion was correct. It should be upheld. The lack of standing and the application of the speech or debate clause to this particular case are more than sufficient to uphold the motion to dismiss. Judge Contreras' opinion is correct as a matter of law, and this court should uphold it.
Thank you, counsel. All right, counsel for appellants.
I regret that we didn't talk about immunity before, because I think it's a little unfair to my colleague to have me say what I'm going to say now, which is all in our briefs. There is no speech or debate.
Previously talk about what?
Immunity. Oh. When I was at the podium, we talked about standing. And
so what is your argument?
Essentially, the Westfall Act provides no immunity. It's more of a double negative. What the FTCA does is it waives sovereign immunity for damages. It has nothing to do with injunctive relief. It waives sovereign immunity for damages, but under Passman versus Davis, there is no sovereign immunity for, or rather, there's no common law sovereign immunity for members of Congress outside of the speech or debate clause. So if we're right that this is not within the speech or debate clause, he has no immunity whatsoever. What the Westfall Act does is it says.
I think our questions have tried to make you focus on the allegations in your complaint and what your claimed causation is and how we could redress that.
I think so if we're right about immunity, which I didn't discuss before because you didn't ask me about it, if we're right about immunity, then we could perhaps amend the complaint to address standing. So it's, in other words, we lost on two.
Yes, I mean, you can always refile too, but that's not the case that's before us. And suggesting that on reply seems somewhat inappropriate, counsel. Too late.
Well, we have argued throughout in their complaint that if you think we have a redressability problem, we can name the third-party companies.
Of course you can. You could have done that in the beginning in the district court, and you discussed that. So what else do you have to respond to?
Okay, so there's some
argument before the court.
There's some FTCA case law from before 2016 that suggests that there's immunity here. But the Simmons case basically acknowledges that that statute, all the exceptions to the FTCA are prefaced by this chapter does not apply to the following exceptions. So if you're in one of those exceptions, and the parties here agree that we are, the discretionary function one here, if you're in one of those exceptions, the entire FTCA, including the Westfall Act, doesn't apply. So the Westfall Act does nothing. Passman versus Davis says that immunity for a member of Congress is limited. There is no sovereign immunity, common law sovereign immunity like you all, judges and members of the executive branch have. There is none in the executive.
That's the reason I asked.
Okay. Yeah. Thank you, Your Honor. So again, if you take away this one basis that the district judge thought we were dead, how do we know he wouldn't let us amend? We'd asked in our complaint to let us amend. Don't dismiss us unless, don't dismiss us. Let us add the third-party companies if that's a problem. We said that. We don't want to sue Google if we don't have to. That obviously would entail difficulties for us. But the district judge viewed an immunity problem and a standing problem. We say the standing problem is curable. He's wrong about the immunity problem. Of course, the other side says that he's right about both. And if the other side's correct about that, then there's no point even arguing about standing because there's immunity. But if there's no immunity, I believe we ought to be able to correct. We pled that we wanted to correct if it were necessary. And actually, if I may, in closing, the Simmons
We
case.
are clear, though, counsel, after the district court ruled, you never filed a motion to amend your complaint in the district court.
It would have been futile, Your Honor, because of the
just
second.
asked you yes or no.
Oh, I'm sorry, I'm having a little difficulty hearing you. Yes, you are correct.
In
We
the
did not.
district court, after the district court ruled against you, did you file a motion to reopen, reconsider, and amend your complaint?
Your Honor, no, we did not. And the reason we did not is because it would have been futile. If it were just about standing, we could have. But because of the immunity holding, which we disagree with, we needed to bring it here. And I believe under 28 USC 1653, we could still, it would be unusual certainly, we could still in this court today, or after I write it, file a motion to amend the complaint. I'm not saying we should do that, but I do think we could cure the standing problem. And if we're right about immunity, we'd have a shot here. We didn't have a shot in district court. And I do encourage you to invite opposing counsel back to discuss the Simmons and the FTCA and the Westfall Act, because I think those are very important issues, separate and apart from this case. Is there nothing further?
My counsel, if my colleagues have no further questions, then thank you, counsel, very much. We'll take the case under advisement. Are we ready to have the deputy call the third case?
Case number 20-1516, Fast Food Workers Committee and Service Employees International Union petitioners versus National Labor Relations Board. Mr. West for the petitioners, Mr. Heller for the respondent, Mr. Shaw for the respondent intervener.
Okay, please, the court. Sorry.
Thank you, counsel for petitioners.
Yes, Your Honor, John West, together with Michael Element, representing petitioners.
Would you like to start your argument?
May it please the court. This case began in 2014 with a complaint filed by the NLRB's general counsel against McDonald's Corporation and many of its franchisees, alleging widespread unfair labor practices on a nationwide scale in opposition to a union organizing campaign. These were not alleged to be individual actions taken by the individual franchisees, but rather part of a coordinated effort by McDonald's directing the activities of its franchisees on a system-wide basis.
So, counsel, since your time is limited, why don't we just hone in on the critical issues here? And the argument is made by opposing counsel that some of your arguments are not properly before the court because you never gave proper notice that you were appealing certain matters.
I'm sorry, I was having a little trouble hearing at the beginning, Judge Rogers. You're talking about the...
I'm talking about whether the recusal issue is properly before the court.
Your Honor, I think there are two answers to that. Number one, the appeal of the raising the issue of the board's refusal to reopen the hearing certainly was properly brought before the court, in that the board's order was attached to the notice of appeal. And I think the other point to be made with respect to whether this is properly before the court is that you
can't just include an order. We've said over and over again, you have to explain why you're challenging an order. It doesn't work to just put it factually in your papers.
I appreciate that, Judge Silberman. I believe there may have been some ambiguity in the notice of appeal, but the scope of what was being brought before the court certainly was made clear by the fact that this document was attached.
Well, the docketing statement references both, and for some reason, whoever filed these talked about the original decision, and then in response to, was a petition for rehearing filed? Yes, and what happened? And then you cite the rehearing denial. All right? So then you acknowledge that when your statement about issues to be raised, you didn't specifically mention the second denial. And then in your opening brief, of course, that's your first argument to this court. So your argument, as I understand it, is under our decision in Cinderella, we have jurisdiction. Somebody talking? We have jurisdiction to consider this issue. Now, you know what your opposing counsel are going to say, so this is your chance to respond if you want to.
I apologize, Your Honor. I wasn't clear on whether you were finished with your question. Your Honor, what I would say is we think we've addressed in the brief the reasons why the issue is properly before the court. To the extent that's not persuasive, I'm prepared to go on and discuss what I think are more important arguments, namely with respect to why the board abused its discretion in overruling the administrative law judge.
Well, you know that intervener's brief goes on and on and on about why the recusal issue is not before this court. You think your brief adequately responds?
There are two points, Judge Rogers. Number one, the argument, there's one argument that the motion to reopen the record is not before the court. And that's what I understand us to have been discussing just now. Even if that argument is correct, the contention that Member Emanuel's refusal to recuse himself is not before the court, I think has no merit, because what is before the court is the board's order accepting the settlement and approving the settlement. And that order was signed by Member Emanuel. In fact, he provided the deciding vote on that. And the question is whether that order is proper, given the fact that one of the members who cast the deciding vote should not have been sitting.
What is your theory of law that supports that argument?
Well, Judge Silberman, I know this is not an exact analogy, but I think it's somewhat comparable to the recess appointment cases, where the Supreme Court was willing to say that you have this whole range of cases decided by the board that are essentially null and void because somebody participated on the decision who should not have.
Is that a due process violation?
Yes.
I'm sorry.
Is that a due process violation, having a disqualified member decide a case?
Well, I think it's perhaps a due process violation, and perhaps also a fact that it's a decision that has no weight. Is null and void because it was void ab initio.
We decided last year in another case involving the Surface Transportation Board that individual opinions or status or individual opinions of members of a commission or board are not reviewable. That only the decisions of the board are reviewable.
Yes.
Now, as my colleague points out, if an individual is behaved in a certain fashion as to reflect an incredible bias, the argument then would be a violation of due process. That is not, as I see, taken up as arbitrary and capricious, which simply means the decision of the agency is unreasonable. But that would be, I think, as my colleague points out, you would have to make a constitutional due process argument.
Yeah.
And you didn't do that.
We did not do that, Judge
You
Silberman.
did not on appeal or not anywhere.
But do you concede the premise of his question?
The premise being that it's a due process
Yes.
violation. Whether there is, as you're pointing out, Judge Silberman, whether there is a due process violation or not, you're correct that we have not argued that.
I thought in one of our cases, and I'll get the name of it, we had said that a decision by an unbiased board, that a litigant has a right to a decision by an unbiased decision maker.
That's correct. But that
And the question here, it seems to me, and I want to ask counsel for the board if he can explain this a little bit to me, of how recusals work before the board. Because one of the questions I had in my own mind after you filed your motion to reopen, and as you point out, your motion for recusal was pending. Didn't the member at issue know what was on his recusal list? Because his statement does not deny that in any way. He simply says he didn't represent anyone in the administrative proceeding here. But that is not the only question under the board's and the federal ethics standard that applies here. And under the board's regulation, there's that third prong about conduct that could reasonably give rise to an observer. All right, so that the person wasn't coming to the case with an open mind. I don't see that having been addressed.
Well, we certainly argued in our brief that
No, I mean addressed anywhere by the member individually, much less,
Right.
by the board. And to the extent the board didn't have to say anything, although it had that long footnote too, in its opinion.
Yes. Yes, I agree that that was not addressed. And I think this is almost like, if I could suggest an analogy, if you could imagine two parties that have maybe a business partnership, and it goes sour and they break up. One of them then later sues the other, and it turns out that the judge who is appointed to hear the case at the time of the partnership had been involved in giving legal advice to the defendant. And his statement as to why he doesn't have to recuse himself is because I was not giving legal advice to anybody, to a party in this particular litigation. And this is what Judge Emanuel, I believe, said as to why he was not required to recuse himself. It's because the legal advice that his law firm, his former law firm, gave was with respect not to this actual litigation, but to the
franchisees.
To the franchisees on the subject matter of this case.
Not exactly, on the election.
Not exactly. His statement is more limited. It's very carefully worded.
Well, but there is a document in the record, I believe it's Joint Appendix 15, where Littler Mendelsohn explains what it was doing for franchisees and the services it would provide to franchisees.
No, I understand it. What I'm saying is the judge's statement was simply that he hadn't represented any party in the administrative proceeding now before the board.
Yes.
That's a more limited statement. It doesn't deal with one part of the board's ethics regulation.
Yes, I agree with you completely, Judge Rogers, and I think that's essentially the heart of the problem here. That he really didn't answer the serious questions.
And the question then, given that you did have a motion for recusal pending, then you filed to reopen, and the board said we're not going to do it. So now it's before us, and we're going to hear a lot of argument about how it's not before us, and you're happy to rest on your briefs, I gather.
Why don't you go to the point you wanted to go to, which is the merits, the key to the case?
Yes, thank you, Judge Silberman, and I'll try to be very brief on this, but our central argument here, apart from the
But I want to be clear, counsel. It may be central, it may be important, and the judges want to hear about it. But you're not waiving or abandoning your argument about why the recusal issue is properly before the court, are you?
No, certainly not.
All right, let's get that on the record.
Okay.
Nice. Now, please proceed as Judge Silberman requested.
Okay, so our argument is that in approving the settlement, in reversing the decision of the administrative law judge, the board abused its discretion. We concede that abuse of discretion is the proper standard for this court to evaluate the board's decision, but that the board, in fact, abused its discretion for two separate reasons. The first was that the board departed from its own precedents, which required it to defer to the administrative law judge without providing any reasoned explanation why it was doing so.
You know what, counsel,
Well,
I
it
was,
went on and on, didn't it, counsel, about why it was doing so? It said we never agreed with this. We proposed a rule change or a rule that's pending.
Yes.
So, I mean, as you know, abuse of discretion, the court doesn't have to agree with what the agency says, but it clearly acknowledged it had this precedent. It clearly acknowledged what its reasoning was. What more did it have to do?
Well, our point is that even though the board purported to provide an explanation in a footnote, I believe it's footnote 15 of its opinion, that explanation simply is not tenable because the board was saying basically that circumstances have changed since the ALJ issued her decision. But with respect to the standard that was going to be applied in deciding the joint employer issue in this case, the circumstances did not change at all with respect to the what was in effect at the time the case was filed.
I guess I have a prior question, which was why is the standard of review that the board applies to an ALJ decision even the type of thing that is binding on the board? I mean, the board ultimately has the statutory authority. ALJs decide cases only, you know, because they have some delegated authority from the board. They don't have any sort of independent authority to decide settlements. So I'm not sure why this should even matter. It seems to me that the board possesses all the statutory authority it needs to make this decision.
That's absolutely right, Judge Rao. The board has that statutory authority, but the board in a whole range of decisions isn't
it fair to say that normally the board will defer to an ALJ on credibility determinations, not policy issues?
Well, what the board said
isn't that fair? You know, I once practiced labor law. I've taught it for 35 years. I've written a number of opinions. I've never seen a case in which it was actually contested that the board had exceeded its scope of review of the ALJ. This is the first time I've seen it. But if it makes any sense at all, it's on credibility questions because the ALJ listens to the testimony, never on policy issues.
Well,
legal questions.
Sure, but what the board said in the Pueblo sheet metal workers case is that its review of the ALJ's decision to accept or reject a proposed settlement is limited to whether the ALJ, and I'm going to quote here, acted arbitrarily or capriciously or otherwise abused her discretion. And I think that the problem here, Judge Silberman, is that the board abandoned that standard in this case. It acknowledged that its normal standard was to review.
Well, as my colleague pointed out, it explained the core issue on which you're fighting, and I understand it full well, is whether McDonald is a joint employer. Now, the board, the general counsel wished to test that issue when he brought the complaint. Under a prior general counsel, because as you and I know, the board shifts around a lot depending on the membership of the board.
Sure.
And the new board, actually the board under you, that you're challenging, had a different view of that question, which is a fundamental legal policy issue, and they were going to handle it in a different way. So why wouldn't, as my colleague suggests, although you might want to defer to ALJs on credibility determination, the board's not going to ever defer to an ALJ on a major policy question.
Well, my first point, Judge Silberman, is that the board, it's not the board that was making the decision here to settle the case. It was the general counsel. And I think you're certainly correct that when a new board majority comes in, there's frequently a change in policies, a change in emphases, and so forth. That's not at all unusual at the NLRB. And when new general counsel comes in, he or she will have separate new litigation priorities and so forth. What I think is highly unusual in this case is for the general counsel, in his capacity as the prosecutor of this case, to simply abandon what had been begun and had gone on for 3 years under his predecessor. I think that's...
Isn't that what always happens when there's a settlement, right? There's a, someone
Sure,
moves forward.
sure, but
Isn't that exactly why Biden fired the general counsel?
But there's a settlement. The board's law makes very clear, and this is in the board's rules as well, that after the ALJ has begun to hear evidence, to receive evidence, that any settlement is an adjudicative function, which is subject to her approval. And here you have not only the ALJ hearing evidence, having heard evidence for 3 years, what she called the longest case in the history of the NLRB, with hundreds of exhibits, 150 hearing days, and almost finished, only 2 more witnesses to be heard from. And the new general counsel comes in and says, "Oh, never mind. We're just going to settle."
The new general
counsel, maybe you want to move on to the merits of the board's decision, given that it decided to review the case not with deference, but de novo.
Okay.
What are the errors in the board's decision in that respect, in your view?
In my view, the central, there are a number of problems that are discussed in our briefs, but the central problem, which I'd like to focus on here, is the fact that under the independent stave test, which I think everybody agrees is the applicable standard here, there's a 4-part test, but the key issue is whether the settlement was reasonable. And what the general counsel, and this relates to what I was just trying to explain to Judge Silberman, the general counsel, in abandoning the whole issue of attempting to hold McDonald's liable, or at least test whether McDonald's could be held liable as a joint employer, after 3 years of hearing, with the record virtually complete, that was simply unreasonable. And it was unreasonable also because, as the ALJ explains in her opinion, and I'd refer the court particularly to pages 644 to 46 of the joint appendix, she goes on and talks about the record that had been compiled having copious evidence showing that McDonald's coordinated and directed on a nationwide basis the activities of its franchisees in responding to the union campaign.
Isn't it fair to say that this joint employer issue is a major policy question that the general counsel was seeking to modify prior board law on?
Yes.
And the new general counsel said, no, I'm perfectly happy with the old board law. I don't want to change.
Okay, but here's the key, Judge Silberman.
Rulemaking.
Pardon me?
And there was a rulemaking.
And there was a rulemaking. So let me get to that in a second. But first of all, in response to Judge Silberman, the standard that the new general counsel was proposing to go back to through the rulemaking was the same standard that had been in existence for determining joint employer status at the time the case was originally filed. And
so in the rulemaking, there is a reference to, independent stave.
Independent stave, yes.
So that signals, in a way, I suppose, that the board wasn't proposing to abandon that. Is that your point?
Well, I don't think they were proposing to abandon that. What they were proposing to abandon was the board's Browning-Ferris decision.
I understand that, but we're trying to get to the standard here that you're saying the board didn't follow. And all I was saying is there was this proposed rulemaking, but it didn't abandon independent stave, did it? No.
No, it didn't, and I don't think anybody suggests otherwise. But so the board was proposing through this rulemaking to abandon the broader Browning-Ferris standard that had been adopted by the board in 2015. But this case was brought in 2014 at a time when the standard that the board was proposing to go back to, the narrower pre-2015 standard, was in effect. And that's the standard
But
under
counsel,
which...
you've got to deal with the point that all three judges have noted. You know, new administration comes in, new general counsel comes in. He says, I know everybody spent the last 3 or 4 years on this matter, but here's my position and here's how I want to proceed, and works with some of the respondents and says, I'm satisfied with this settlement, and submits it to the ALJ. The ALJ doesn't like it. The board is satisfied with it. So what is the court to do? And I mean, you can think hypothetically, a new assistant not assistant, but a US attorney comes in, and his predecessor's been spending years on an investigation, and he says, I'm not pursuing it anymore. You know, I'm done with it. I want to settle this matter. So I'm just asking you to focus on, let's just, for purposes of argument, assume that the new general counsel could so proceed. What was wrong with the settlement? Either under independent states, since there's no suggestion it's abandoning that, or as a matter of law, or as a matter of firmly established policy that the board did not propose to abandon.
What was wrong with the proposed settlement is that the general counsel no longer had the authority on his own, without agreement of the ALJ, to adopt a settlement.
Oh, no,
And-
wait a minute.
Well, we've been through that. So my question is, and the issue that I had in thinking about this case was, you have the petitioners and you have the respondents and you have intervener. And the settlement, as I understand it, did not purport to have the agreement of the petitioners.
That's absolutely right, Your Honor.
Well, is that a problem or not?
Well, it's certainly something that needs to be taken into consideration.
Well, the board took it into consideration. I mean, they knew what they were doing. What I'm asking is the cases before us. And normally when you have a settlement, everybody may not be happy with all of it, but the parties have come together. Here, not the charging party, but the complaining party was not amenable. And I thought part of the argument was, well, once you file a complaint with the board, what happens to it is the general counsel's decision, not the complainant's decision. So what's your response to that?
Your Honor, we are not arguing that the refusal of the charging parties to agree to the settlement in and of itself made it unreasonable or illegal. But it's certainly a factor that was very important, particularly given where this case was after 3 years of litigation, and given the terms of the settlement, which basically absolved McDonald's of any liability as a joint employer. What the settlement provided. So, and I want to emphasize in this regard, where we have evidence that the ALJ discussed in her opinion, showing that McDonald's was coordinating and directing the anti-union efforts that led to these unfair labor practices, you have a settlement that imposes no penalty at all on McDonald's. The only things that McDonald's were required to do
Just collect the money and pay it out.
Collect the money from somebody else and pay it to the board, none of its own money. And if there was any breach of the settlement by any of the franchisees, then McDonald's was required to send out a supplemental notice, but a notice in which McDonald's disclaimed any liability for the franchisees' unfair labor practices, disclaimed any liability for a breach of the settlement agreement, and disclaimed any liability as a joint employer. I'm sorry?
Isn't it fair to say from the beginning of this proceeding, from the beginning of the chart, in this case, the question of the relationship between an owner and franchisees, whether they were joint employer or not, was very much up in the air.
Up in the air in the sense of not being resolved?
Right.
Yeah, that's true.
Okay. So you have a new general counsel comes in and says, you know what? Not only do I not want to try to answer that in this case, but after all, there's going to be a rulemaking on this question. But most importantly, put aside the rulemaking. I just don't want to answer it in this case.
Well, my response to that, Judge Silberman, is simply that that is not within the general counsel's authority at that point.
Why?
Because the board's rules say that once the ALJ has started to receive evidence, which she'd been doing for 3 years in this case, a settlement can be reached only with the agreement of the ALJ.
No, it doesn't say that.
Ultimately, the
It
board.
doesn't say that. The ALJ doesn't have a veto.
I think that's wrong, Judge Silberman. I think
your argument is her decision is reviewable as on abuse of discretion.
No, okay, so
But not that she has a veto.
she has a veto in the sense that she can veto the settlement as she did, but her veto is reviewable by the board.
Oh, okay.
I'm sorry, I was not clear on that.
And that's a policy call.
Well, it's a policy call. Certainly, the board's decision to engage in a rulemaking to try and
No, even determining whether her position should be supported or not was a policy decision.
Well, it was a policy decision for the general counsel, but the determination as to whether the settlement that put into effect that policy decision was reasonable under the independent state standards.
It's up to the board, and the board made a policy call.
It made a policy call, but it's not free to just say, this is the policy we want to engage in, therefore we think it's reasonable.
Why?
Because the board is required to follow and apply its own precedents.
And one of the factors would be consistent with a policy call on that.
Well, one of the factors in the independent state is whether the settlement is reasonable, and for all the reasons.
And for the board the board thinks it is reasonable, which is a policy.
What the board said is in its footnote 15 is that it was going to depart from its general practice of deferring to the ALJ's decision because of the changed circumstances. And part of my argument here, Judge Silberman, is that the circumstances were not really changed as far as the standard that was going to be applied in determining joint employer as compared to the time the case was begun and what was going to be put in place by the board through its rulemaking proceeding.
Even if we assume that that's correct, that is somehow unreasonable, I think you have said, for the board to decide. I mean, how is it an abuse of discretion? Because you conceded that our review of the board's decision is abuse of discretion.
Yes.
I mean, if reasonable minds could disagree about, whether there were changed circumstances or the like, then don't we affirm the board?
Well, your review is for abuse of discretion, but the board abused its discretion in this case by by approving a settlement that was contrary to its standards in independent stave. Judge Rao, let me just say that if you all were to agree with me and hold that the board abused its discretion and send this back to the board, it would not be the first time this court has done that. I would refer you to the oil, chemical, and atomic workers case written by Judge Edwards back in 1986, where the posture of the case was very much the same. The ALJ had rejected a settlement. The board had overruled the ALJ and approved the settlement, and this court found that to be an abuse of discretion and sent it back. Because the board had not explained, and there it was not explaining at all. Here it's not explaining satisfactorily its reasons for departing from its precedent.
Okay, why don't we hear from our counsel for respondent?
Good afternoon. May it please the court. Joel Heller for the National Labor Relations Board.
Hi, Mr. Keller. You heard me mention I was going to ask you about recusal procedures before the board, or rather, let me put it this way. If I were to be appointed to the board, would I be interviewed about my recusals?
Would you be interviewed about your recusal?
Well, how would the board know what I thought I couldn't, what kinds of cases I could not sit on?
Sure. Well, so board members are subject to the two standards we discussed in the brief, the Office of Government Ethics regs and the executive order. And
that's not my question, counsel. What I'm trying to understand is the brief is written as though the judge here didn't know anything about the statement of recusal involving McDonald's. Is that correct? Or he knew about it, and that's why his explanation of why he didn't need to recuse in this particular case was limited as it was.
So Member Emanuel consulted with the board's designated agency ethics official in making the recusal determination. That is the process, the internal process for determining recusal obligations of members. And so he did that here. And in consultation with that officer, he decided that he did not need to recuse from this case. And that's the explanation in the board's footnote.
Okay, but I just want to understand, suppose there was no question at all that the judge, either just before he was appointed or just after he was appointed, said, do not assign me any cases involving McDonald's. Who determines after that what cases the judge may be assigned? Or is that just each and every case up to the individual judge, by individual board member, excuse me?
Are you talking about the kind of internal mechanics of how cases are assigned?
No, she's asking who would make the decision.
Sure.
Is this decision made by the individual board member? Or I think what my colleague is saying, does the full board as a whole answer the question?
I see. So in this case, the recusal motion was addressed to Member Emanuel, and Member Emanuel individually, in consultation with the agency ethics officer, decided not to recuse in this case. And
so then that decision was never reviewed or commented on by his colleague?
It was not commented on. I mean,
footnote 2 goes on about it for a long time. So you can't say he didn't comment on it, but they acknowledged he had made this decision.
Sure. The other members on the case certainly permitted the decision to issue So in that sense, they were aware of his recusal determination and did not, I suppose, object to it because.
Well, there's only one other person on the case, right? And one other board member.
Well, there's the dissenting board member as well, and she talks about in footnote 1 of her decision comments on the recusal issue. But the recusal issue is subjected to an abuse of discretion review in this court, and I think it clearly meets that. It's not grounds to reverse under that standard.
So an abuse of discretion, as we and other circuits have held, is not only sort of the judgmental discussion that my colleague was having with petitioner's counsel, but it also involves whether there was an error of law. So when the recusal decision is, I was not representing any party in the case before me, period. But it doesn't say anything about what I may have done when I was working for the law firm that was actively engaged, undisputably, with the underlying facts here of the $15 request and the unionization drive. And yet the board's regulation has 3 parts to it. And that statement doesn't address the 3rd part.
So, Your Honor, there are not separate board regulations on ethics obligations.
Yes, there is. You cited in your brief. Everybody cites it. It's not at issue. In that sense, it is a regulation of the board.
These are regulations from the Office of Government Ethics. Those are government-wide ethics obligations.
All right, but the board does not deny that it applies to the board.
Correct. That's what applies to the board. And so I'm saying—
And your brief particularly addresses it.
Member Emanuel addresses those regulations.
I'm talking about section 2635.502A.
Correct. And that is what is addressed in that footnote 2. In a way, it explains that Littler Mendelsohn, his former law firm, did not represent a party in the particular proceedings of this case. And that is the
regulation has 3 parts. All right. One is where you have a direct and predictable effect on the financial interest of a member.
Which is not an issue.
Or you know a person with whom he has a covered relationship or represents a party to such matter, and where the employee determines that the circumstances would cause a reasonable person with knowledge to question his impartiality in the matter, comma, the employee should not participate unless he has informed the agency designation of the appearance problem and received authorization from the agency designee in accordance with paragraph D of this section, right?
Yes, correct, Your Honor. And so that part, there's 2 parts to it. We're putting aside the financial conflict because no one claims that that's it.
Right.
The next part, though, there are 2 prongs to it. First, that there has to be a former employer or someone with a covered relationship, in this case, a former employer, is or represents a party to this matter. That's 1. And 2,
a person with whom he has a covered relationship.
Yes, and that would be a former employer.
Or represents a party to such matter.
A person with whom he has
doesn't say or, it says and.
It says
it says or. There are 3 circumstances, and if you fall within any one of those circumstances, then it says and where the employee determines blah blah blah.
Correct. And so the person with whom he has a covered relate. So this is when you're recused. If 1, a person with whom you have a covered relationship is or represents a party. That is not met here. because Littler Mendelsohn does not represent a party. And then prong two, and a reasonable person with knowledge of the facts would question your impartiality. Since prong one is not met, you don't have to get to prong two. But even so, Member Emanuel does address in that final paragraph of footnote 2, he does say that he does not believe his former affiliation with the law firm would, under the factual, legal, or temporal circumstances here, quote, cause a reasonable person with knowledge of the relevant facts to question his impartiality, quoting the very language we were reading here.
Then why did the motion to reopen attach this statement saying that he was recused from cases involving McDonald's?
So the motion to reopen, which again is reviewed under an abuse of discretion standard, tries to put in this document here. But as the board explained in its order denying that motion, the document would not require a different result, which is the standard for granting a motion to reopen. It does not change any of the underlying facts about the fact that Littler Mendelsohn does not represent a party in this proceedings. It does not engage with the legal analysis about that were the basis for the motion to recuse, the OGE regs or the executive order. And it was from well before the motion to recuse was filed, and even longer before the decision issued in this case.
Well, but there was a decision to grant a special appeal. Oh, incidentally, what is a special appeal?
A special appeal is essentially an interlocutory appeal.
Is that defined by an agency regulation somewhere?
Yes, it is.
Do you have the
site is, but that's what a special appeal is. That's why you need permission to take a special appeal in addition to the board ruling on the merits if it grants permission to take the special appeal.
Thank you.
You're welcome. And so, right, the decision to recuse was made by Member Emanuel in consultation with the agency ethics officer, and that is the decision that is under review here. The recusal list that the committee wanted to put into the record comes from a different office within the agency, the executive secretary's office, which is essentially the clerk's office for the board. And even if that was made in consultation with the agency ethics officer, it clearly wasn't her final views on the topic, because 21 months later, when the recusal decision was actually made, it was clear that Member Emanuel had consulted with her. And
we don't know what she thought. He consulted. All right.
She disagreed with him, I suppose, in the consultation, but under the OGE regs,
the point is, it's his decision.
It is his decision.
All right.
So his decision is set forth in the decision here. It is not represented in the document that the committee attempted to put into the record, and that is a high standard for reopening the record. You must show extraordinary circumstances and that it will require a different result. And the board's determination that it would not require a different result is reviewed by this court under abuse of discretion.
And so you read covered relationship to mean what in the regulation?
Covered relationship. Yeah, so if you look at the definition section, it looks like Roman numeral 4. A covered relationship is any person for whom the employee has within the last year served as ... an employee. So the relevant definition of covered relationship here is a former employer, Member Emanuel's former law firm.
Right, and when he voted on the special appeal, how long had he been with the board?
The special appeal came out in December 2019. He had been at the board since September 2017.
So not quite 2 years.
A little over 2 years. He had been at the board. So September 2017, he came. The decision was issued December 2019.
Thank you.
Right, but I mean, even if there is a covered relationship, it's not with someone who is or represents a party. So there was no recusal obligation here under the plain language of the OGE regs. So moving, if I may, to the merits of
I just want to be clear from the board's perspective. Then, if I am appointed and confirmed as a member of the board. And I have spent my entire life professionally working for law firm A. And I've been involved with all of their significant clients. Nevertheless, I, under this regulation, can decide I am not required to recuse, because no reasonable person with knowledge of the relevant facts would question my impartiality because I'm not representing anybody who's in the administrative proceeding.
Well, it's not about
Is what?
It's not about whether you represent someone. It's whether your former employer, your former law firm represents someone.
Well, that's why I asked you what a covered relationship was. And so my covered relationship is I've been working for this law firm forever. And now this law firm is before me in a case involving presumably one of its major clients. And my hypothetical is, you know, I've been a very important member of the law firm all these years, working with all its significant clients. That's all I'm getting at.
So in your hypothetical, is your former law firm is now appearing before you as a board member in a case?
No,
Because that's not,
no.
I'm sorry that I
My
misunderstood.
former law firm is in the case before me, before the board. The general counsel complaint makes allegations against my former law firm. So there's no problem, you're telling me, under the Office of Government Ethics Regulation 502?
There would not seem to be a problem if your former firm, I guess, was the charged party in a case, if there was a board case against your former firm. I don't, under the OGE regs, that would not by itself be enough to dictate your recusal.
Even though the party who is specifically named, namely these franchisees, operate under an agreement with the client my firm represented while I was with the firm.
So the only evidence in the record of Littler Mendelssohn's involvement with McDonald's or its franchisees is
With
that
all
they...
due respect, we know what's in the record. I mean, your brief says what's in the record. It held this, hotline that franchisees could call in connection with unionization and the $15 raise.
That is correct. That was their involvement in 2013 and 2014.
Yeah.
And recusal motion was filed in 2018.
After the complaint.
Recusal motion was filed well after the complaint. Yes, it was not until the special appeal of the ALJ's rejection of the settlement that the recusal was filed. Speaking of the settlement, the board has broad discretion whether to accept a settlement in lieu of further litigation. And the board acted within its discretion, in this case, to accept a settlement resolving one of the largest cases in agency history. There's a deferential abuse of discretion standard for such issues, and the committee offers no compelling reasons to upend the resolution of this case. The analysis
standard, no compelling reasons?
That is our argument, Your Honor. And
is that the standard?
Oh, sorry, is that the standard? The standard is abuse of discretion.
Right.
So this determination that the settlement was reasonable is reviewed by this court for an abuse of discretion. And that analysis is informed by two overarching principles. First, the board and the court's longstanding recognition that settlement is a key component of federal labor policy. And second, the fact that all settlements entail compromise. So we go on at length.
The compromise here didn't get the complainant's consent or agreement.
That is correct.
That's what's unusual about this settlement, it seems to me.
Well, the first prong of the independent stave standard is whether the parties have agreed, the position of the parties. And so the board found that that was neutral here because some parties agreed with the settlement and some parties disagreed with the settlement. But the fact that that is a prong of the analysis means that there are going to be some times when some of the parties don't agree. Because if any party could veto a settlement, that would be the end of the story. There wouldn't need to be any other factors. And of course, the board and courts have long said that one party cannot veto, a charging party cannot veto a settlement agreement on its own. You have to show that the settlement was a reasonable one. And for the reasons we discussed.
That's what I'm trying to focus on, all right?
Yes.
What the complaint alleged, all right? And then a new general counsel comes in and we've been through, he can change his view on policy. But nevertheless, even in the notice of proposed rulemaking, on which the board is relying, the new general counsel to the board is relying, independent stave is still the standard.
So independent stave is the standard for reviewing a settlement. The rulemaking has nothing to do with settlements. The rulemaking has to do with the substantive.
I know, but they cited independent stave favorably. They weren't suggesting they were abandoning that. That's all my point is. It presented it as though it was law with which was agreed. There's nothing, if the rulemaking is finalized, there's nothing in there that says now we no longer apply independent stave standards.
The rulemaking has nothing to do with independent stave. Independent stave is the standard for reviewing settlement agreements.
Well, I wonder why they cited it.
They don't cite it, Your Honor.
They do. It's in the notice of proposed rule. It's in the record. I'm not making this up.
Well,
You haven't seen it?
As for why it would be mentioned, the
It's
rulemaking.
It's in the analysis of why we're doing this, and it goes on with a number of things. Okay, so, all right, you can have a settlement where basically the complaining parties don't get what they want, and they get a complex system, and I understand it now, and tell me if I'm wrong, that the back pay claims have all been, resolved?
The back pay was
and the only question is future findings of violations?
The settlement agreement provides for 100% of back pay to all of the employees who suffered monetary damages as a result of the alleged violations.
Right.
That money pursuant to the settlement, that money has all been paid, and actually had been paid at the time the settlement agreement was initially introduced.
So there's no claim by any employee of one of these franchisees that it's entitled to back pay and it hasn't received it?
Correct. They received all of the back pay.
Well, because my understanding is the way the settlement read, if the allegation wasn't in the complaint, the original complaint that was filed, you couldn't recover. Is that correct?
If there were future violations by the franchisees that were the same as those violations alleged in the complaint, the employees would receive a payment out of the settlement fund. So if a franchisee had discharged an employee for engaging in union activity, and that was alleged in the complaint, that employee would already got money under the settlement. But then if in the future that same franchisee discharged another employee for engaging in union activity, that employee would receive money out of the settlement fund without need for any further litigation.
So I thought what you had to do is you have to file a notice, or you have to file a claim.
Someone has to inform.
McDonald issues a notice, and then you, the employee, have to file a complaint. Is that not right?
If there was another violation, it was the same type
violation. That's what I'm getting at.
if there was a subsequent violation by the same franchisee, then someone would have to inform the board about this, but then there would be a payout from the settlement fund.
Counsel, you're jumping the gun here. There's an allegation of a violation. There hasn't been any determination yet as to that future violation, that there was a violation. And as I understand it, the way you get that after McDonald's issues the notice is you file a complaint.
So no, under the settlement, the payment from the settlement fund does not require starting over at the beginning and going through the entire board process, filing a charge, a complaint, a hearing, and so on. You look at page 63 of the joint appendix, kind of towards the bottom, that explains, that's one of the settlement agreements, explains how the settlement fund works. So if a regional director of the board finds that a franchisee has breached the settlement by committing the same type of violation.
My point is the regional director is acting on a complaint filed by the employee. He's not sua sponte doing this. The regional director has to make some findings of fact as to whether there was a violation or not. Just because the employee alleges it doesn't mean there was.
I suppose there would have to be some internal investigation.
Yes.
In order to determine, right, but once the regional director has made that determination.
Right, but I'm just talking about the burdensome process on the employee, who after all, we keep hearing this case has been going on for so long, et cetera. And now everybody wants to get rid of it, but it takes care of back pay. But as to these future allegations, you have to get a decision out of the regional director. So you have to file a complaint. How else would you get a decision from the regional director?
Right. Kind of as a matter of fact, under the process of the settlement, yes, you would have to get some kind of determination from the settlement or from the regional director, but you would not have to go through the entire board process that you would have to if there was a new complaint, a new charge filed.
You'd have to file a complaint that the regional director could resolve. That's my only point.
Correct. And that is something that is unique to this settlement agreement. If we didn't have this, if you didn't have the settlement, you would just have to start over and go through the entire process. So there is a benefit to this settlement of the creation. Well,
I don't think that's the issue here, is it? Because the case could have proceeded absent a settlement. I mean, suppose the new general counsel didn't like the proposed settlement.
If the case had proceeded and there had been no settlement, and we went all the way down the line and we got a decision in favor of finding a violation, the order that the board would issue would not include a settlement fund. So this is something that you get as part of the settlement that you wouldn't get.
Yeah, you don't know. At any rate, if the board issued an order and then, the hearing decision on individual claims, the franchisee would have to pay. And the franchisee can negotiate that with McDonald's. That's all I want to get. I mean, in terms of understanding the board's decision that this was a reasonable settlement.
Sure. And that is, the settlement fund is one aspect of the settlement, certainly. But overall, the board's determination that this is reasonable is based on the facts that it provides immediate and certain relief to all of the affected employees. It remedies all the alleged violations. It essentially accomplishes much of what full litigation on the merits would have done.
Well, I understand the back pay is resolved. I wasn't clear that the retaliation claims are resolved.
So there were three types of... I thought
you had to go before, a regional director, file a complaint and go to the regional director.
The retaliation charges in the complaint, or allegations in the complaint, are all resolved by the settlement agreement. All violations are resolved by the settlement agreement. There's money payout, there's notice posting, there's notice mailing, which again is something that wouldn't generally be a part of a board order after full litigation. So that's another bonus.
The franchisees and McDonald's agreed to pay out money for all these alleged violations?
Yes, 100% of back pay for all of the alleged violations.
No,
That's
back pay is not the same thing as damages for retaliation, and you know that, counsel, better than I do.
so
Back
under
pay is different. But you're telling me all the retaliation claims have been resolved in favor of the employees, and you're saying that's been done through the payment of back pay.
back pay, interest, and what's called the compensation for the consequences of tax consequences of receiving a lump sum.
Yeah, but you understand what I'm getting at, don't you? Back pay is one thing.
I don't understand what you're getting at.
You don't?
I apologize.
You don't
Under
understand the
board order.
difference between back pay and damages for retaliation?
Not under the NLRA. Not under the NLRA. I'm correct. It's only back pay.
It can be both, Judge Silberman?
No authority on the board to award damages.
Under current law, there are no compensatory damages, if that's what you're getting.
Right.
It's only a board order, monetary remedies is back pay, interest, and the adverse tax consequences that I mentioned before. That's what you get under board law as it currently stands. And that's what the employees got under the settlement.
Okay. So the only thing that's outstanding then, taking what Judge Silberman and you just said, is future possible violations that are alleged against the franchisees.
I mean, if there are future violations, then
Oh, yes, allegations. So that would be the only thing that isn't
Then
resolved.
in that event, the board would proceed through contempt.
Yeah.
if there's a breach of the settlement agreement by virtue of there being further violations, then yes, that would then trigger the default proceedings under the settlement agreement, where the board reissues general counsel reissues the complaint, and get a default judgment by the board and a consent judgment from the Court of Appeals, and then of course the franchisee or McDonald's, as the case may be, would be subject to contempt.
Right. So we're back where we were. You've got to file a new complaint. Anyway, counsel, I understand. Thank you, Judge Silberman. Anything further from my colleagues?
No.
Thank you all. We ask you to.
Thank you very much. So, counsel for respondent intervener.
May it please the court, Pratik Shah for intervener, McDonald's, USA. In my limited time, unless the court prefers otherwise, maybe I'll go straight to what the petitioners call the key issue in their argument here today, and that's whether the board abused its discretion in approving these now fully consummated settlement agreements just because they did not allow for further development of the joint employer law in the way that they would prefer. As Judge Silberman has said, that is a policy call. But if there is any doubt about whether the ALJ's policy preference as to that call should trump the judgment of the Senate-confirmed general counsel and the Senate-confirmed board, that doubt has to be resolved in this case by the time of the board's decision. There can be no doubt that the board's decision in this case, whatever the general answer might be, was reasonable because, as the board explained in great detail in its opinion, it had already initiated a formal agency rulemaking to revisit and clarify joint employer law. So therefore, the ALJ's reasoning, the principal reason the ALJ disapproved these settlements was the ALJ believed the case should be remanded so it could develop joint employer law. But by the time of the board's decision, the board already had a rulemaking pending on that. And as it turns out, that proposed rule is now a final rule that is in the books that will dictate joint employer law going forward as a prospective matter.
Would not the board position be authorized without regard to the rulemaking?
Yes, Your Honor. And that's where I started with. Your premise is correct. This is a judgment policy call. The ALJ's policy preference cannot trump that of the general counsel and the board. If the court doesn't want to go that far, but that is the correct answer, you could stop there. If the board if this court wanted to instead rely on the typical APA principle, which is as long as a board explains its decision as to what it's doing, then you apply normal abuse of discretion review to the board. Here, that happened in spades because the board explained it makes no sense to rely on the ALJ's justification that remand would allow for development of joint employer law when they have a rulemaking which wasn't initiated at the time of the ALJ's decision, but had been initiated since and is now, in fact, a final rule.
Well, there's an interesting point here. The board, I understand, it takes the position. Put aside the rulemaking in the future.
Sure.
We do not believe that the ALJ's view of joint employer is correct.
If that were the basis, that would be adequate in and of itself.
The trouble with the rulemaking, that deals with the future, whereas the question before the board is whether, or before the general counsel, is whether there was a violation of law, which is retroactive, which is passed.
Right.
And we've just dealt with cases in which the board agencies improperly look to rulemaking to answer present adjudication.
Sure.
So although the important point is the board did not believe the ALJ's view of joint employer was correct under existing law.
Correct. The board explained in its opinion that unlike the ALJ's view of it, it was not a slam dunk that they were going to prevail on, that the charging parties were going to prevail on joint employer law. In fact, joint employer law had been a mess. And in fact, McDonald's, despite many cases in all sorts of different forums, has never been held to be a joint employer. The board pointed that out. It pointed all of that out and said, in light of that, this settlement is very reasonable. It provides the actual victims of the alleged violations, every employee, all 181 violations fully redressed, 100% compensation. They would not have received a cent more, even if this had gone on for years. They had received full judgments from the board on appeal, affirmed not a cent more. Under that context, the board said, this is a very reasonable settlement. The only aspect of the settlement was the joint employer.
I'll go quickly to your jurisdictional point.
Yes.
You're generally correct. We review a board, not an individual member's position. We've said that in a recent opinion last term for the Surface Transportation Board. However, if it was determined that one of the board members had taken a bribe or had financial interest in the case, wouldn't that be challenged on due process grounds?
Yes, Your Honor. In that case, I would not have my jurisdictional argument anymore because you would
still have your jurisdictional argument. You would say you can't do that under arbitrary and capricious. You have to bring a constitutional claim of violation of due process.
Exactly. So if, in fact, you had a case where, as your hypothetical states, it was a bribery claim, I would expect the other side would have brought a challenge that says this violates due process. There's actual taint, actual prejudice, due process violation, give me relief.
Now,
they have not made those arguments.
Next question, I want to be very quick on this. This government-wide rule on recusals.
Yes, Your Honor.
Why is that binding on the NLRB?
Perhaps that's a question better given to agency counsel. They have taken the view, Your Honor, that there are two sources of binding ethics obligations. The first source is the executive order ethics pledge, which, again, their only argument under that is directly and substantially related. And we know that directly and substantially related is defined in the executive order to mean that you that you are a party or represent a party.
All right, the next point.
But could I just ask here, just as a follow-up, counsel, I didn't read the board's brief to suggest it wasn't bound. Now, whether or not, as Judge Silberman's question suggests, maybe it isn't, but
No,
that was never challenged by the board, was it? It simply said that it had no authority to review the decision because it was an individual decision.
I agree. I was just curious about the point. And
I just want to be clear about that the board has never argued that it doesn't apply.
I understand. I'm just curious. Now, do you take the position that any violation of your rules would be equivalent to a violation of due process?
Any violation of the board's rules?
Right.
I would not answer yes to that question if I were the board, but if you're asking me as McDonald's, I don't think that would be, because due process, and there's jurisprudence on this, the standard is different. You have to show like actual, it's a heightened standard, right? The rules, you may be violation of the letter of the rule, but that doesn't mean that you haven't gotten a fair shake. That may be an appearance concern. It may be this sort of thing.
I think you're right. Okay.
And just to square the circle as to why you're asking these, perhaps, is they have not made any of those other bucket of arguments that would fall into the due process camp of actual bias, bribery, actual taint. And that's why we haven't addressed them. If they had, they would be meritless.
Right.
Well, counsel, one of the things in reading last term's decision, I thought, well, how did that three-judge panel have authority to overrule all of our previous cases on what the standard is about due process? That, a litigant is entitled to an independent decision maker. You didn't need to address that because you weren't arguing it, but just Judge Silberman's question.
Right, Your Honor, just to be clear, they have not made any sort of due process or other sort of arguments. Their arguments on recusal are limited to the two regulations that we've talked about, the executive order and the CFR regulation. And it is now undisputed, and obviously you can ask Mr. West to confirm that there is no dispute that Littler Mendelsohn is neither a party nor represents a party. That is a requirement under either the executive order or the federal regulations to get recusal. They do not satisfy that requirement. So even if this court has jurisdiction and they properly preserved it and dotted all their I's and crossed their T's and you issue merits, it's not even a close call. And it's definitely not an abuse of discretion on behalf of Member Emanuel or the board for him not to be recused in this case.
Thank you.
If there are no
further?
Oh.
Anything further from my colleagues?
Oh, thank you.
Thank you, counsel.
Thank you.
We will hear from counsel for petitioners.
Thank you, Your Honor. And I have 3 points that I would like to make, and I'll try to be really brief on all 3 of them. First of all, as to the argument that both counsel made, that the settlement accomplishes most of what the litigation would have done, that the people could not have gotten a penny more. That's correct with respect to the 20 individuals who had been fired or had their work time shortened or things like that. But it's a really important principle that the board has often repeated, that this court has often repeated, that the board is to function, but the board's function is to be performed in the public interest and not solely in the vindication of individual rights. And I would refer you again to Judge Edwards' decision in the oil, chemical, and atomic workers case, where he, after quoting that principle, he says, in a footnote, really what our role is in reviewing the board's decision to accept the settlement. Our role is really not unlike that of a district court in reviewing a class action settlement, in that it's not sufficient to determine that the interests of the individual named plaintiffs have been taken care of. There's a much larger issue at stake.
But isn't it the general counsel who's supposed to represent the public?
He is, and if he doesn't, this court is there to remedy the situation, I would think, and that's our submission, Judge Silberman. That is, he did not represent the public by capitulating to McDonald's on the critical issue in this case. There was a mention. My second point: the board's rulemaking the board's rulemaking is going to resolve everything because you'll have all these issues that are coming up in this case resolved through the rulemaking. That's not at all correct. The rulemaking is on the general joint employer standard. That's true, but it does not go in at all specifically to the context of franchisor-franchisee relationships. And here on that particular point, you had the ALJ making a record over the course of 3 years, going specifically to the nature of the relationships between McDonald's and its franchisees. And what the general counsel did is simply threw that all away, all of that effort, and capitulated on that issue. And finally, Judge Silberman, in response to your point that that there had been no determination, that the ALJ, the general counsel disagreed with the ALJ's determination about joint employer. That's not quite correct, because in fact there had been no determination made by the ALJ. What she ruled on was simply whether the settlement was reasonable, and had that not been overruled by the board, then she would have had the opportunity to take the evidence that had been assembled over the course of 3 years and apply the joint employer law as it existed at the time, whether under Browning-Ferris or under the board's new rulemaking, and apply it to the facts of the case that had been assembled through this very arduous and lengthy hearing. And what the board did is the general counsel did, approved by the board, it foreclosed any possibility of doing that and addressing that point on the basis of the record that had been assembled.
All right. Anything further from my colleagues?
Not me.
No.
All right.
Thank you.
Thank you, counsel. We will take the case under advisement.
Pen, please. This honorable court is now adjourned until Monday, December 13th at 9:30 a.m.